May I please? So I beg to mention item number 20, bail hearing matters,
Item number?
20. CD not received, Lordship.
Well,
Rather maybe
CD not received, madam.
Show reminder for city. List
On 29/10, madam.
29,
27th, Lordship, maybe. He is
27th.
behind the bar, 27th,
2710.
Lordship. May I please, your Lordship?
Item number 35, Lordship. It's a FOXO matter, Lordship.
Mhm.
Service is not completed upon response number 2. The matter may come after 2 weeks, Lordship. Any date after 2 weeks, Lordship.
You are on interim bail.
Not interim, Lordship.
So service report upon respondent two awaited.
Awaited.
List after 2 weeks.
Any date, Lordship.
On 19/11.
19.
2 weeks.
Two
He's requesting 2 weeks.
Then on
Last part.
4/11.
4/11. Obliged.
May I please, your Lordship, I beg to mention item number 6, Lordship. In this case, Lordship, I was on transit interim protection, Lordship,
Mhm.
but I was supposed to issue notice to PP of the jurisdictional court,
Mhm.
Lordship. And I could not collect the address of the PP, Lordship.
Mhm.
Give us some time to collect the address, then I will take step, Lordship. 6.
We'll do it now only or let it come up? We call it a learned council. Seek some time to furnish notice to the jurisdictional PP as address has not yet been, could not be collected as yet. Stop. The prayer is allowed. The interim bill stands extended till the next date of listing. Let it be somewhere in the middle of next week. Is it okay?
Yes.
You can suggest a date. Can also suggest middle of next week,
on
31st.
31st.
Sorry, not 31st. Next week,
23.
24.
24. Okay, 24.
Oh.
Interim fight order date একটু লিখে দিব, হ্যাঁ? Date.
Lordship, I beg to mention item number 36 for the passover for the day. The conducting council has some personal difficulties, so
Oh.
will not be able to appear today, Lordship. Item 36.
36.
30.
CDS come?
CD come. CD.
Or CDS come?
36.
6 and adjourn for the day on the prayer of the learned council. CD be retained. Interim is there?
No, Lordship, it's a regular bail.
No, 36, you said?
Yes, item 36, Lordship.
36 is AB. It's an AB. Anyway, there must be, probably there's no interim.
Yes. On
Anyway, check
22nd.
করে লব, হ্যাঁ? একটা cross check করে লব। Interim যদি আছে, it has to be extended.
23.
Case diary has
Case
come.
diary received.
Case diary be retained. 2310.
Obliged, Lordship.
36.
My pleasure, Lordship. I am praying for listing one anticipatory bail application, my lord, on Friday, my lord.
New matter, kindly mention it before the senior bench, okay? You know,
Oh, my lord.
if it's time, you can try, otherwise at 2, you can mention there.
May it please your lordship, I beg to mention item number 21. Service report is not received. So kindly fix the matter for next week.
See, scan TCR. Service report is awaited, 21. Service report is awaited.
On my
List
lord,
the matter on
on 29/10.
2910. Okay?
My lord, already this court, my lord, rejected on
Oh, then you can. Friday, for Friday.
Friday, my lord. Obliged, my lord.
May I please, the last item, my lord, 49. In fact, my lord, here in this case, the steps has been taken
Mhm.
for a service on respondent, my lord, the respondent 2,
Mhm.
and that service is awaited. My lord, I pray that your lordship may fix this matter after 2 weeks or 3 weeks, my lord. 49, my lord.
49.
My lord.
Respondent number, service of respondent number 2 is still stated to be still awaited. And 6, 2 weeks adjournment, which is allowed. List the matter after 2 weeks on. You can suggest a date.
Lordship can fix it on any date, my lord, as per lordship's convenience. At least 3 weeks may be granted, my lord. So that, my lord, he appears.
Should we just say list after 3
My lord,
weeks?
my lord, correct.
List after 3 weeks.
Yes, my lord, in fact, there is an interim order that will be continued, my lord.
List after 3 weeks. Just a minute. If we fix a date, then it will be, say something.
Right.
Like 1, 2, 3. Let it be on 6/11.
Correct.
6/11, the interim order granted by the order dated so and so shall stand extended till the next date of listing.
Deeply obliged.
Lordship, I pray for Lordship indulgence to mention item number 48. My lord, it's a criminal petition orders matters.
Mhm.
I've checked the office note, my lord. LCR as called for by this honorable
Not
court
come.
has not been received,
Not
my lord. Reminder may be issued to the court. And my lord, with regard to the service upon the respondent 2 and 3, my lord.
Mhm.
Respondent number 2, address is changed to Mumbai. We have already communicated. There is chance of compromise also. So I pray, my lord, that the service upon 2 and 3, my lord, by speed post as well as dusty may be permitted, my lord. That is my
Item 48.
48.
The issue reminder for the scanned TCR. Full stop. Further, on the prayer of the learned counsel, the petitioner side is permitted to take steps, fresh steps upon respond number 2 and 3 by speed post.
Speed post as
well
dusty,
as by dusty service
both, my lord.
and submit compliance thereof.
Yes, my lord.
Some-
My lord, lordship may fix a date first week of November as per lordship's convenience, my lord, any date. my
I
lord.
do not know how many matters would be related. You know, it can be on 7th.
My
List on
lord.
7/11.
My lord, deeply obliged, my lord.
Or you want later after that also?
No, my lord, that is fine, my lord. Deeply obliged, my lord.
I beg to mention item number 39, Lordship. It's a bail hearing matter. Updated CD is not received as per instruction, Lordship.
AB, right?
Kindly adjourn the matter for a day, Lordship.
CD
39,
Case
CD
diary.
case diary not received. Issue reminder, are you on interim?
CD received.
Yes, Lordship.
CD is not updated, man. CD is not updated.
Oh,
Statement of the petitioner is not available.
let me again cut it here. The case diary is received, but
Interim
stated to be not updated.
Interim.
Therefore, it may be sent back and procured again with updated investigation. Interim bail granted by order dated so and so stands extended till the next date of listing. List after, after
On
3 weeks,
10/11 month.
list on 10/11.
Lordship. Much obliged.
Then,
May I please, your lordship? My lord, I have filed a criminal petition, my lord. Earlier it was listed also, my lord. POXO matters, my lord. And the informant also, my lord, we have served the no copy, my lord. And their advocate also, my lord, filed wakalatnama. So thereafter, my lord, as the date is not fixed, my lord, the matter has not been listed, my lord. So it come up after Diwali, my lord, on 22nd, my lord. Obliged.
22nd, I think
Is open, my lord.
open.
My lord. Obliged.
Your lordship, the matter is for listing for orders. It's a IA matter for a POSCO.
Also matter, I think that's before senior bench, no? IA matter, that's, kindly mention it before senior bench. That's all. At 2 o'clock you can mention, the time is up.
Yes.
In this case, already notice was issued, lordship, and as per our last office note 1310, lordship, service is awaited in respect of respond number 2, lordship. Notice was issued on 22/9/2025.
This matter
There is
actually may
office
come up for-
1310, lordship, service report is awaited
Oh.
in respect of respond number 2.
We'll have to wait. no?
Yes, lordship.
This matter may come up for orders, man. Cancellation of.
Wrongly listed for motion.
For orders. You got a charging land council. Yeah. Service report, upon respond number 2, not yet received back. Await, stop. This is the matter after, how long should I fix?
After 2 weeks, lordship.
List after 2 weeks, in the orders column.
Yes, lordship. Alright.
May I please, your lordship? Lordship, in this matter, petitioner is behind the bar for 261 days, lordship. And he is seated under section 21 of POXO, for which punishment is 6 months, lordship. Lordship, kindly have a FIR at page
12 have been arrested, your lordship. So as on date, 60 days is over intermediate quantity, your lordship.
After some time, I will get the instruction.
Please take the instruction.
At 2 PM, your lordship.
Yeah.
At 2.
2 PM or earlier, whatever
Leave
time.
Leave obliged, lordship.
May I please, your lordship, it's a regular bail application. It is a NDPS matter, my lord, search matter. So
I'll record, maybe call for my lord.
Yes, record. Call for the scan case diary and scan charge sheet of charge sheet. Trial has not started probably.
Not.
So, CD and charge sheet will be NDPS 83 of 25. Corresponding to delay PS case number 20 of 25 from the Court of Learned Special Judge Karbi Anglong Diffu. The accused is stated to be in custody since 22/4/25. Good stuff. Release the matter on
13/11.
Obliged, my lord.
May I please, your lordship? My lord, this is a POXO case. Lord, can very make pulpit.
With inside the house of the accused number 1 and also cut their heads badly and also injured them. Thereafter, while they wanted water from the accused for drink, then they urinated and feed them their urine. Thereafter, the accused persons imposed penalty of rupees 30,000 to the guardians of the said boys. So, Lord, this is the allegation, lordship. Actually, these 4 boys, lordship, they were caught red-handed at the shop of the accused number 4, lordship, not by us, lordship. We are not their lordship. We are the only villagers, lordship. And accordingly, lordship,
Who's the petitioner?
lordship, petitioners are lordship accused number 2 and 3, lordship. And shop owner was the accused number 4. His shop was stolen, theft, lordship, by that 4 person, lordship, at public court, lordship, and that the handed over to the accused number 4, house of the accused number 4, lordship. And we, lordship, later, lordship, when came to that, they came to know that some persons were caught as theft, lordship. Then we went the lordship to see the situation, lordship. And we sorted the some assault is there, lordship. Yes, definitely their lordship stolen some property, lordship.
You know, these are the who are someone is juvenile.
Yes, they are juvenile, lordship, 14, 16 and 17 years, lordship. Their lordship, as they are the villagers, lordship, same village, lordship, they are instead of giving the police, lordship, their lordship handed over the guardians, lordship. And some penalty was imposed, their lordship, that is correct, lordship. And we, lordship, we only supported the penalty, lordship. That's all, lordship, our names is their lordship.
That urinating in their, yes, very bad.
That is maybe done by the others, lordship, not by us, lordship. We, lordship, later, lordship, after, that's it, they were caught at the night, lordship. And at the morning, lordship, we were in their lordship. Whatever happened, lordship, that is happened earlier, lordship, not by us, lordship. And then, lordship, we discussed, lordship, and said that the person also admitted that they several occasions they committed the theft, lordship. Several occasions they admitted. That's all, lordship. Some penalty was imposed upon the guardians, lordship. And we support. We support
policing, my lord, without intimating the police, my lord. They how.
That is even then, lordship. Even society
Human conduct is not good.
Yes, maybe their lordship, but even the lordship.
That's not good. But you are denying that.
Yeah, I deny lordship. And we go in the letter, lordship. Whatever done, lordship, the cutting the hair and whatever done, that is the other public, lordship. We, lordship, morning, lordship, at the morning time, we went the lordship. So, lordship, whatever happened earlier, lordship, we cannot say, lordship. And because, lordship, only we supported the penalty, lordship.
482 bill application. Taking petitioners so and so in connection with Boko PS case 298 of 25 under section so and so PNS, read with section 75 of juvenile justice. The petitioners are adult, no? They are not juvenile.
They are adult. They are adult.
The accused persons were juvenile.
Yes,
CIGL.
Without intimating the my lord, police.
They are young people.
Yes.
Anyway, maybe you know. I
Even
cannot
the
take
thief
law in my
lordship,
hand.
the thief court lordship, they are
Anyway,
public lordship.
leave it. They'll record. Go and record their statement.
Yes.
Gist of the allegations is that some boys were caught with committing theft of sweets from one shop, tea shop, of accused number 4 in the FIR, and it is further alleged that then all the FIR name accused caught them, and instead of handing over to the police, assaulted them inside the house of accused number 1, cut their hair, and also urinated in their mouth. So it is further alleged that the accused persons imposed penalty of rupees 30,000 to the guardians of the boys. Learned Counsel submits that the present 2 petitioners are not involved in the act and they had only come on the next morning. and supported the penalty. Full stop. Third additional PP, call for the case diary from the concerned police station. With a view to allowing the petitioners to record their version of events, comma, it is directed that in the event, in the interim, in the event of the arrest, 25,000 with 1 subject to the condition that number one, will cooperate investigation and appear before IO, comma, making themselves available for examination. Number two, they shall not intimidate or harass or threaten the informant slash victim side in any manner. This is the matter.
12-11.
12.
Highly honorable, sir.
Hmm? 51. Now, government advocate name is shown, no?
Yes, Lord. I served a copy upon them.
Someone is
Your
appeal.
Lordship, kindly after some time I will inform you.
$52. $52. 52. No? Yes, yes.
52.
SC.
52.
Oh, no, after some time. None appears. After some time, or maybe ICST Act, it's yes, 52. After some time. SCST Act anticipatory bail is maintainable or is within a small window.
Yes,
If prima facie material is not there.
Yes, yes.
Prima facie case
Then
is
not
not there.
maintainable.
What is the judgment? Judgment is there.
Yes.
Because 18A, section SCST Act 18A, that removes this anticipatory bail. But when that was challenged, I think this judgment was made laid down. 50.
Ma'am, please also. Look, as per last order, my lord, my learned friend was directed to obtain instruction whether, my lord, there was any report by the public prosecutor, my lord. In fact, there is
Oh,
a,
this
yes.
one.
In fact, it's a case, my lord, where, my lord, after expiry of the mandatory period, my lord, extension was granted, my lord. That was, my lord, in fact, on the basis of one application filed by the investigating officer, my lord. So that's why, my lord, my learned friend was directed to obtain instruction if there was any report of the public prosecutor, my lord.
Could you?
Otherwise, my lord, yes, my lord, regarding instruction, from the record, my lord, itself, my lord, reflects that, yes, only on the basis of the, my lord, application of the investigating officer, my lord, that extension application was allowed.
In that case, you will be entitled to default
Yes,
bail.
that order itself reflects.
Should I dispose it?
Yes.
আগৰ অৰ্ডাৰটো মমি সেইটো একে থাকে ফাৰ্ষ্ট পেৰাগ্ৰাফটো চাই সেইটো সেকেন্ড পেৰাগ্ৰাফটো একে under bail on the ground that's also he has invoked on the provisions of 483 BNSS with regard to Morigao PS case number 353 of 24 under section 22C of the NDPS Act. The prescribed statutory period for commercial quantity is 180 days, comma, which is further extendable up to 1 year by the special court on a prayer of, on a report of the prosecutor, public prosecutor. Referring to the impugned order dated 26/6/2025, the primary contention is that the extension was made after expiry of 180 days and also merely on the report of the IO. The learned additional people, what should I submit on your behalf
Regarding
today?
instruction, my lord, though I could not get any instruction from the IO, but
From the report,
from the report order itself reflects.
the learned additional people submits that instructions could not be obtained, but from the materials, the impugned order, it appears that the order was passed mainly on the IO of the report, the report of the IO. Full stop. Upon perusing the impugned order, it is I find that it is stated therein that the statutory period was over on 25/6/2025, and charge sheet has not been submitted. IO of the case file report, we have to go by the, as far as the order is concerned, the file report, there's no reference to the report of public prosecutor. right?
Yes, no reference to the report of the publication and by impugned order dated 26/6/2005. Although, my lord, that petition was filed on 25, but order was passed on 26. And in that order also regarding report of the public prosecutor, there is no reflection about the order of the public prosecutor. A public prosecutor has filed the application on the basis on behalf of the IO.
From the order, it is also revealed that the IO had filed the report on 25/6/2025. Full stop. The provisions of as per the relevant provision of section 36A, such extension has to be based upon the report of the public prosecutor. And it is well settled. There are many case laws, but
Yes,
it's
yes,
not
yes,
referred.
madam.
Time also, doing well, time. It's, and it's well settled that the report of the IO is not a substitute for the report, not a substitute for the statutorily mandated report of the public prosecutor. Therefore, in my considered view, the extension was not legally correct, and consequently, the present accused had become entitled to default bail at that time. In such view of the matter, the accused so-and-so is hereby allowed to go on 50,000 with one surety of the life amount to the satisfaction of the concerned learned court, which will be Session Judge Morgan.
Yes, madam. Session Judge Morigaon.
Morgan. Surety of like one surety like subject to the conditions, number one, he shall be available for trial. Number two, he shall not hamper or tamper with evidence. He shall not misuse his liberty to commit any illegal activities or offenses. Actually, the report, even if the order is passed later, this is an important
Yes,
cap.
that report of the, my lord, IO.
It has to,
Yes.
it's within the time.
Report of the public prosecutor is not there, only on the application is
Yes, yes.
filed by the IO,
Yeah.
no public
No,
prosecutor.
but if the court passes the order after expiry of the period, then also it may be valid if the report is filed before.
Yes,
Yes.
around 25.
Before that.
Yes.
Before that.
It was a learning experience for me in NI. There's a judgment which was placed by one learned counsel. I benefited from them, Ravindran.
Yes, Rabindran, yes.
Ravindran case, that it has to be within that period and
Yes.
it is,
So
if the
within
court
the-
passes this later, that is not the prosecutor's fault.
Yes.
But the application was filed on on
Before it expires.
Before the expiry.
Before it expires.
I'll give you a plus one. My lord, item 14, my lord, that is the criminal petition, my lord, where we have challenged this particular order, my lord. And there, my lord, scan copy of the LCR not received, my lord, your lordship may keep it or, my lord, dispose it off.
No, the thing is that actually I mentioned only that should I then delete that part? That because this extension, only if the extension is incorrect,
Yes.
then only bail can be granted.
Yes, yes.
Statutory bail. So in a way, actually also
Yes.
disposes of this.
Yes, yes.
We have to pass an order, formal order.
Yes, yes.
So what should we do?
Your lordship may dispose it off also, here, my lord, item number 14, my lord. Because this is not in, my lord,
Else because that order was already, my lord, invalid because of which illegal, for which your lordship has already granted bail.
Yes.
So otherwise keeping the matter pending, my lord.
What you do is, just, all of it, last 20, first two paragraphs same. So, those scan TCR has not been received, but in the context of order passed in BA number so and so, I think this matter may not be kept pending and can be disposed of. Full stop. তাৰপিছত নহয় আমাৰ বেইলৰ যিখিনি কণ্টেণ্টছ সেইখিনি উঠাই দিব আৰু মই আগৰ অৰ্ডাৰটোৰ এণ্টায়াৰ কণ্টেণ্টছটো ইয়াৰ তলত বহাই দিলেও মই মিলাই থাকিব। The criminal petition stands allowed and disposed of on the aforesaid grounds.
I'm deeply obliged.
This was which item number?
That is item number 14, my lord. Criminal petition, my lord. 1216.
At the stage of admission.
Yes, yes. I'm deeply obliged. Item number 15. 15.
15, my lord, it is a POXO matter. Service is awaited, my lord. So let us give a chance. We will take a instruction, my lord.
TCR has come.
My lord, TCR, my lord.
Scan TCR has been, item 15. Scan TCR has been received, but service with regard to private respondent is awaited.
Yes, ma'am.
Full stop. Prosecution shall take steps. List on. List on.
My lord,
You can suggest a date from your calendar.
my lord, 22nd, my lord. 22nd, or my lord, 17th.
Say 22nd.
22nd. My lord, 16, my lord, I need some time, my lord, go through the TCR, my lord. May it be fixed at, my lord, 2, my lord. NDPS matter, commercial quantity, my lord.
Not. Deeply obliged.
My lord, here also it is a POXO matter, my lord. Amicus already appointed, my lord. Learned Amicus is present, my lord. But my lord, I need some time, my lord. Mera may kindly be time being, my lord. In the meanwhile, I will go through the, my lord, record, my lord.
May I plead your lordship? Petitioner is behind the bar for last 132 days.
Now it is 100. At that time it was 112 days. Now it is 132 days.
112 days.
Now it is more. Now it is more. As on today, it is more.
Yes, yes,
25/9, it was 111 days.
yes.
So
and
everything is complete. We can discuss.
FIR is on page number 13.
We'll take it after some time.
After some time, my lord, I will go through the record, my lord. Today itself, my lord, before 2,
Today?
my lord, before
Today?
2, my lord.
Okay.
This half only.
My lord, can it be taken up?
2, my lord, commercial quantity, my lord. Both the NDPS matter, my lord, if fixed or
May
2, my lord.
finish early also.
My-
2 or earlier.
I will also, my lord, go through the record.
May I plead your lordship?
The 86 days behind the bar, my lord. Section allegation is 309 and 27, 309 BNS and 27 Arms Act, my lord.
86 days behind our manor. Case diary was called for, but we have not received the case diary also. 90 days is mandatory manor. Considering manor length of detention.
When, which date?
After holiday is mandatory will be over.
Oh, no, just.
Okay, 17 of
17.
17.
Listed on 17. Okay.
Available.
May I please, your lordship? Lordship, it's a regular bail application, lordship. Case diary was called for whether it is available. Lordship will find the FIR on from page 10 to 18, lordship. Lordship on page 12, lordship.
He was arrested on 12/9.
Arrested on 9,
You mentioned.
12/9, lordship, 34 days, lordship, as of today. Lordship, the gist of allegation is there, lordship. The complainant is a police personnel. As on Naka checking, they have found a truck carrying 600 bag of PDS rice, and those rice were recovered, lordship. And later on, the accused, two accused persons were forwarded. The petitioners in this petition, petitioner number 1 is the owner of the rice, and petitioner number 2 was the driver, lordship. Lordship, after the arrest was made, lordship, we have produced all valid documents relating to, lordship, this rice, lordship. Lordship, the petitioner number 1 has procured the said rice, which was alleged to be PDS rice, procured the said rice from Sumon Rice Mill, which is on page number 20, from page number 24, lordship. Lordship will find it in our annexure, lordship, annexure number 3, page from page number 24, lordship. Lordship, then the rice was supposed to go from Borpeta to nearby Assam border, Assam Meghalaya border, 9 mile, Bornihat, lordship. Lordship, in that way, lordship, e-way bill was also procured, which is an online bill, lordship, generated on 10/9, lordship, on page 30, lordship. This Salan,
I've seen.
yes. Thereafter, the Hussein Trading Company has procured the rice from Suman Rice Mill, and the UA bill was generated so that the transportation can be made from Borpeta to 9 mile Bornihat. Before the truck gets to 9 mile area, the police apprehended this person on Bokisto, on Naka checking, lordship. And as per allegation, it is a PDS rice, lordship, but it is not a PDS rice, lordship. It is privately acquired by the petitioner number 1. We have tried to give all the receipts and all the documents to the police personnel, but they denied to receive it. We have even approached the senior officers so that the investigation can proceed by taking the receipt into hand. But the senior officer also denied. Then we have the petitioner has approached, the petitioner's family member has approached appropriate forum so that they can give the receipt, lordship. Lordship, we have the document regarding sending of all those valid receipts so that it can be a part of the investigation, lordship.
How much it has progressed?
Well, investigation regarding those, my lord, he has submitted those documents that needs to be verified by the police, and regarding that whether those rice were PDS or not, my lord, I have one statement of the purchaser, my lord.
Lordship, we have intimated the Accountability Commission that they have denied to receive this, our valid receipt.
Whether those documents were very genuine or not, my lord, that needs to be verified by the policeman.
I think it can be, because this thing is there, no.
And I have gone through the photographs, lordship. If it is a PDS rice, the bags will contain government seal and everything, but those bags does not contain any government seals.
Let them go at this stage.
Yes.
আছে আপোনালোকৰ? Sorry, received it, but the material now, 26/9, first two paragraphs. First two paragraphs, same. What are you looking? It's contended by the learned counsel, Mr. Mehdi, that the rice was stated to be, alleged to be a PDS, which was found in the truck, have been validly purchased. And in this regard, attention has been drawn to certain purchase receipts and EUA bill. It is also submitted and contended that this aspect of the matter was brought to the notice of the IO as well as IO, and upon refusal, it was brought to the notice of the higher police authority without success. Full stop. Thereupon, the matter was ventilated for the Police Accountability Commission. The case diary has been received. Full stop. It is submitted by learned additional PP that the documents submitted from the side of the accused have to be verified. Nevertheless, in the aforesaid facts and circumstances and progress of investigation so far, I deem it fit to grant bail to the accused this time. Also keeping in mind their detention so far already, detention undergone already so far. Also keeping in mind their pre-trial detention undergone already so far. Accordingly, they are allowed to go on bail of rupees 20,000 each, surety of life. Subject to the condition that they shall cooperate with remaining investigation and not hamper or tamper with evidence. You can submit again.
Yes, Lord.
After getting liberty
To the satisfaction of CGM Kamrup Metro.
to the concerned learned CGM Kamrup Metro.
Metro. Deeply,
You can take this, return back the case to
deeply obliged.
disposed of.
May it please your lordship, kindly pass over the matter for time being.
May I please, your lordship? This is the part that matter, your lordship.
Which
Your
one?
lordship,
Just a minute. Just a minute. In the earlier matter, Bothakur, in the earlier matter which was timing, it was a medical report is received. Yes. Medical report is received. I'll see it later, but just asking, otherwise we'll have to postpone it in any case by a short date. If it is received, then we can take it up. Some medical report was called for, I think. Anyway. So,
lordship, actually, I am going to the outside for the another matter, your lordship. You want to take in time, your lordship. It's not possible for me, so may allow me for, kindly lordship, may allow me for submit my matter, your lordship.
just a minute.
This
Let
is
me-
the part that matter, your
let me
lordship.
refresh, just a minute.
Part that hearing, your lordship.
Oh, अच्छा, अच्छा. Oh, no, I remember now. Could we get in Supreme Court decision?
Lordship,
Some Supreme, we were discussing about one Supreme Court
Yes,
decision.
your lordship, that submission my senior will be able to
Okay.
make, your lordship, and he is not available at the moment. He will appear, your lordship, but after some time.
After some.
Kindly pass.
You're
over.
going now?
yes, lordship, I am going to the outside, your lordship. Actually, I have another matter in the Silsor court, your lordship.
Silchar.
Yes, lordship. So, lordship, it's not possible for waiting to me, your lordship, so may allow me for the.
You
yes,
make
my
your
part-
submission and then I'll hear. it.
Okay, well, lordship,
You can connect online also if you want.
lordship.
Okay? Oh. Now I'm
No,
remember.
no, online is not possible, your lordship, because I am going to the from vehicle, your lordship.
No, no, you can. Oh, if you drive, you cannot.
Yes,
Otherwise, you can, connectivity is there still, but Meghalaya, that side, I don't know, Silchar. If you are driving, certainly not, but otherwise, you can, I mean, their part you can do, not your part. Your part I'll take now.
yes, lordship, yes, I am saying.
Not submission from
Okay,
vehicle.
lordship, okay.
In
the
exigency,
last-
one can submit from vehicle also, but it's not so necessary. I'm saying that when they submit, if you are not there, you can just hear if you want to.
Yes.
Go ahead, now I'm remembering the case.
Yes, Lordship. Actually, for the last dated, Your Lordship, my submission is here, Your Lordship. I have submitted one of the division-based judgment of the Calcutta High Court, where
The good judgment.
page number 30, Annexure 8, Your Lordship, where Your Lordship, the DRI has submit the FSL report after 235 days, Your Lordship. And when he has completed after 180 days, I have filed a bail petition before the trial court, Your Lordship. On that time, his bail was rejected because the charge sheet submitted. And charge sheet has been submitted without the FSL report, Your Lordship. This is the illegal, Your Lordship, because without the FSL, how can I say that it is the morphine or what kind of quantity we have find? I never say it, Your Lordship, on that time, Your Lordship, when I have filed that petition. And on that time, after 235 days, Your Lordship, forensic report has been submitted, Your Lordship. And before forensic report, they have submitted the charge sheet. Actually, Lordship, this is the procedure. After completed the investigation, after that, charge sheet submitted. If FSL not submitted, that it is the investigation also not completed, Your Lordship. So, Your Lordship, our bail petition was rejected by the trial court, Your Lordship. I have submitted in my petition, Your Lordship. I am submitted my petition in page number 24, Annexure 5. This is the rejected order of the trial court. Before submitted forensic report, I have filed this bail petition, Your Lordship. On the 28/11/2024, my bail petition was rejected by the court, Your Lordship. And Lordship, the accused person, Suzanur Rashid, he is the local person and he is the student, Your Lordship. I have submitted of his admit card also on the page number 28, Annexure 6. He is
Page
the
number?
Page number 28, Annexure 6, Your Lordship. The accused person is the local person, Your Lordship. And now I'm saying it that, Your Lordship, he is in custody 1 year, 7 months, 4 days, Your Lordship. And page number 29 is his certificate, Your Lordship. This is the certificate of the Suzanur Rashid, Your Lordship. He is the BA first semester and his bearing roll number is 141 for the academic session 2023 to 24. And Your Lordship, one of the incident report of the DRI, after arrested by the DRI to the accused person, they have searched of his house, Your Lordship. But no any articles recovered from his residence, Your Lordship. There have an offense report, Your Lordship. Incident report is here, Your Lordship. On 21/8/2024, a team of officers of DRI, Guwahati, comprising of Sri Biswajit Bora, Senior Intelligence Officer, Sri Bisal Rai, Intelligence Officer, and Srimati Annie Ansemlo, Intelligence Officer, went to the residential address of Sri Suzanur Rashid, located at village Salpara, Molandubi, part number 1, Post Office and PS Krishnai, District Gwalpara, Assam, 783126 in order to verify the residential address of Sri Suzanur Rashid, who was arrested on 10/3/2024 by DRI GZU for carrying 2015 grams of contraband morphine drugs. After inquiry with the local people of the above said village, the officers were able to locate the house of Sri Suzanur Rashid, son of Harunal Rashid. A lady opened the door who identified herself as Srimati Sahida Begum, and she informed the officers that she is the mother of Sri Suzanur Rashid. It was a small kacha house, Lordship. A statement of Srimati Sahida Begum was also recorded under Section 67 of the NDPS Act, wherein thus stated that her husband works as a mason in Meghalaya. And she also stated that her son is pursuing his college degree and he was never involved in any illegal activities before this instance, and the fact that they had applied for bail for Suzanur Rashid in the instant case, but it was not successful. Lordship, DR never said by the DRI that he is involved in this crime, and the DRI also here mentioned that the DRI also mentioned here that he has meet the local people and the inquiry about it, but no any found, and because they have not mentioned in this report, incident report, Your Lordship. This is the incident report, Your.
Right.
Yes, Lordship. And Lordship, where is he? Is the custodian 1 year and 7 months? There have a one BN number 2279/2025. This person is the out of state, Your Lordship. He has granted bail in the long incarceration, Your Lordship. In the Honorable Supreme Court, it Ravi Prakash versus the state of Orissa, reported in 2023 SCC online SC 1109, has observed that the prolonged incarceration generally militates against the most precious fundamental rights guaranteed under Article 21 of the Constitution of India, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37 Clause 1, Clause B.
This is the Orissa High
Clause-
Court, Captain. Orissa High Court.
Yes, Clause 2 of the NDPS Act. Your Lordship, now my question is that, Your Lordship, the search has been framed on 12/12/2024, Your Lordship. Now today is month of October. Since no any witness has been cross-examined, Your Lordship. This is my point, Your Lordship. And the last of the dated, Your Lordship, 15/9/2024, Lordship. This is the status report, Your Lordship. I have collected it from my e-court services, Your Lordship. They have directly mentioned that the learned counsel of the accused, I am the learned counsel of the accused for the trial court, Your Lordship. I am waiting all day, but no any witnesses cross-examine, Your Lordship. And status report to court go. Authority distributed to my. Status report to. Yes, Lordship. On the order dated 15/9/2025, that complainant DRI is represented. Accused Sujani Rashid is produced from custody. Learned counsel for the accused is present. Witness Diken Pegu is present. However, due to paucity of time, evidence could not be recorded. Means this is the last evidence that, Your Lordship. No any witnesses now cross-examined, and there have already I have submitted on that day 8 witnesses, Your Lordship. No any witnesses now cross-examined, and the accused person is the local person. My grounds is that, Your Lordship. He is the student also, Your Lordship. And after then the incident report also, DRI never submit mention in DRI that no any articles are recovered from his residence, Your Lordship. So, Your Lordship, I am saying it that where the articles are recovered, actually, Your Lordship, that is the public place also. And if he is the peddler or he is the habitual offenders, maybe mentioned by the DRI in this incident report, because they have meet the local person also. They have inquiry also. They have mentioned on the second para in this incident report, Your Lordship. So my question is that, Your Lordship, now a judgment of the Satindra Kumar Antil versus CBI reported 2022 10 SCC 51. In this judgment, it has been held that grant of bail of the ground of delay of trial cannot be said to fettered by Section 37 of the NDPS Act 1985, in as much as Section 436A of the CRPC is made applicable to the offense under the NDPS Act, Your Lordship.
Yes.
And Lordship, Husainara Khatun versus Adar versus Home Secretary State of Bihar reported in 1980, Clause 1 SCC 81. In this case, the apex court has observed that the procedure prescribed by law for depriving a person for his personal liberty cannot be regarded as reasonable, fair, or
It's one of
just.
the original cases on right to speedy trial, Senara Khatun, very famous case.
Yes, Lordship. Lordship, may allow to submit the bail application 2279/2025. In this case, Your Lordship, the accused person has granted bail in this grounds, Your Lordship. এখন দি দিয়কচোন দাদা। আৰু this is the last order dated 15/9/2025. This is the proof, Your Lordship. I am the learned counsel. for waiting for the cross-examination of the witness, but no any witness has been cross-examined still now. This is the last order, Your Lordship, 15/9/2025, and BA number 2279/25.
I've seen this. Yes.
Yes, Lordship. And the maximum of the accused person who has granted bail by the Honorable High Court in 1 year of the 6 months in this case, Your Lordship, in this grounds, Your Lordship, where the no any witnesses has been cross-examined. And on that day, last order, dated, I have submitted the BA number 1364/24 also, Your Lordship, and one is 3487/23, and today I have submitted 2279/25, Your Lordship. Lordship, may allow for submit the all the order copy maybe, and allow for submit.
As TCR is also here. Should I keep this set or you want it back?
Yes, Lordship.
I can keep.
Take it. I will be take. Dia Hasmi? Well, he is the accused person, he is the local person. There have been no chance for the absconding. And out of the person who is the out of the state, they have granted bail in these grounds, Your Lordship. So the accused is also right for go on bail, Your Lordship. Otherwise, they have submitted the charge sheet also before forensic, Your Lordship. So my submission is here, Your Lordship. Only on the long incarceration of the delay of the trial, Your Lordship, the accused person has a right to go and bail, Your Lordship, where the Article 21 is violation, Your Lordship. This is my grounds, Your Lordship. And this is the incident report, Your Lordship. This is the incident report, Your Lordship.
You can. It's your compilation, no?
This is my copy, actually, Your Lordship. Incident, kindly go to through the incident report.
This should be sufficient.
Because
Should be
they-
available in the records, I think.
Yes, Lordship, because if he is the peddler, then must be there will be found any articles from his house, Your Lordship. After then searching of his house, arrested by the accused person, after searching the house, they have no any find any articles also, Your Lordship. And he is the student also, Your Lordship. This is my submission, Your Lordship. And I have submitted the BA number 2279/25, Lordship. He is the person of the out of state, Your Lordship, but he is granted bail by this Honorable High Court in this grounds, Your Lordship.
I'll keep this. Compilation thus. You have to keep it. A separate compilation. Note does it? So you can proceed with your work. I'll hear their side.
Obliged, Lordship.
And that's what I was saying. Suppose at the time you are free, not driving, you're in the vehicle, you can just put it on and then hear it.
Okay.
This is the advantage of technology nowadays. Oh, tell them. Kyle, sir, I was not. Okay, next. Oh, this statutory period thing was there, no?
We have not
Actually, we just fixed it in the investigation. We just take an instruction. Whether the, I think 90-day, I think is over. Yesterday.
Yes,
So.
it is 91.
If tomorrow, yesterday, charge sheet has been submitted before the court.
that
Then
is-
otherwise he'll get.
That is instruction we have not received yet, Lordship. It is lying here, Lordship. We have-
CD,
Yeah, Lordship.
yeah, just take the instruction.
Lordship.
Take the instruction, otherwise it will be disposed of.
Lordship.
May it please your lordship. Lordship, this matter was fixed yesterday and injury report was called for to be submitted today, my lord. And I am, today's 46th day, my lord, in custody. FIR is at page 10, my lord.
Just I remember that.
Yes, my lord.
Question.
Maximum punishment is all the offences are below 7 years, my lord. 7 years or below 7 years.
It was instruction was taken by Lanet Panjol Das. Other Bota Lordship, that way Lordship is in court number 14 Lordship. So after some time Lordship, one is Pandolda Hile.
Bails are over. Bails are over. Full hearing. Timings are ready. I said ready. You should take a.
May I please over, sir?
52.
Sorry, Milord, I was in some other court, Milord.
No.
Here, Milord, Lordship is otherwise, in the similar case, in Lordship, Lordship kindly comes to page 147.
SCST Act, right?
Yes, yes, Milord. Here is the other two officials were the Milord, the branch manager, Milord, and the area manager. In the present case, Milord,
SCST Act. Yeah.
in this case, Milord, the present petitioner is the area receivable manager, Milord. Here, Milord, here loan head was taken by one Binod Basfor.
Let us see the FIR.
FIR motion.
As you know, the law, that,
Yes, yes.
otherwise it is not maintainable, I think.
No, Milord, in fact, there is an order, which your Lordship had passed at page 147. 30, order dated 31/7/2025, arising from the same FIR, Milord. The two petitioners therein was the branch manager and the area branch manager, Milord, and this is the area manager as of now, Milord. It starts at page 146. I was granted in these other cases, Milord, the two petitioners were granted interim bail. Subsequently, Milord, your Lordship was pleased to make it absolute.
Yeah, I have referred to this decision.
Yes, yes.
18A had removed anticipatory bail.
Yes, Milord.
But,
Here
but there is a small window given in this case, Kerala case.
Yes.
Just-
Yes, yes, Milord. Same thing will here, the two officials were, the two officials of the finance company was present, Milord. Here, the area manager is the petitioner.
Oh, so this was made absolute.
Yes, it was made absolute.
Because it's like, what was it?
It was in the earlier case, it was the branch manager, Milord, and the assistant branch manager. And presently, the petitioner before Lordship is the area receivable manager, Milord, of the company, Milord. And the Lordship FIR will,
Is he on the same footing?
same thing. Lordship will come to page 30, Milord. This is the FIR,
Now I'm remembering. It's 30.
30.
Okay.
One statement was uttered, Milord. That is why, Milord, this particular section had come up. May I read, Milord? And in
Yes,
fact,
yes, I read it.
Lordship will kindly come to page 25 again. The preliminary report is in my favor.
Where is the preliminary report?
Page 25, NHA 3.
Six known persons. The present petitioner is the branch manager.
He is the area receivable manager, Milord. The Lordship will find it at page 4, paragraph 3.
Just a minute.
For non-payment of installments, the vehicle was repossessed by the NCC, Milord.
When
That
this
is-
statement was allegedly uttered, then this person, he was not
No,
even
he was
present.
not there. He was
He
not.
was in a branch.
He was in the branch. In
According-
fact, it was by the.
On the FIR, it appears like.
Yes,
that.
yes, Milord. In fact,
It seems so, anyway.
even the preliminary
The
report,
staff went, but the
Yes.
preliminary report was it, which page?
page 25, Milord. It is in my favor, Milord. In fact, there is no utterance. That is what they come up, Milord. And so far, Milord, the 5 lakhs that was in respect of the defaulted EMIs, Milord. Page 25 and 26.
Yes. This is the first motion.
Yes.
Let us get the case diary then.
The only thing, is that in the other case also, my lord, lordship at page 144,
Mhm.
I was granted interim, my lord, in view of the same fact, same.
This was disposed of, no?
Disposed of, my lord. Initially, I was granted interim bail by order dated 18/6, my lord. Thereafter, it was made absolute. my
Can
lord.
be done, I think.
As per the FIR, any allegations against the recovery agent or an employee?
Not him.
Not, like.
It has to be a custody slur, intention to, insult person belonging to certain categories. And then at a public place.
Lordship.
Those are the ingredients. Not many cases in our state still.
In fact, my lord, the preliminary report says, my lord, there was no utterance itself.
It, আপনি kindly to page 147 ত যাব bail petition খন আমাৰ এটা orders বহুত একে হ'ব একে হ'ব council লাগে 1 2 3 1 2 3 3 4 5 6 7 হেলো উঠে 7 হলো উঠে next. It is submitted by Mr. Dave, the learned counsel, that the present petitioner, who is the area manager.
Area receivable,
Area network man,
receivable manager, my lord, lordship,
Manager.
paragraph 3.
was not at the place of occurrence also. And moreover, he stands on a similar or even better footing than the petitioners, than the two petitioners in AB number 1368 of 25. Who were granted anticipatory bail by order dated 31/7/25 after having initially granted interim protection. Third, Dipal Goswami learned call for the case diary. Investigation must have progressed a lot, a long time, July matter.
July methodology.
So I will initially not remember. This is an important case law, Sergeant study. I think you had only submitted this. Call for the case diary to ascertain present status of investigation. Further, it is directed that in the interim, in the event of arrest in connection with this case, for the petitioner allowed to go on bail of rupees 20,000 with one security of the like amount, to the satisfaction of the concerned learned. To the satisfaction of the arresting authority, sorry, and subject to the conditions that he will record his statement.
Lordship,
He will
in fact, I have recorded,
Operate with the remaining investigation and appear before the IO, making himself available for examination. Semicolon shall not hamper or tamper with the laws. This is the matter of
7/11/25.
7/11.
But 24 and 26, it was gone through by Mr. Bothaku Lordship. That's why after some time,
Absolutely.
using a court number 14,
lordship.
24 and 26. In this case, also charge sheet submitted.
Started, isn't it? May it please your lordship. Well, page 14 is the FIR, your lordship. Then my charge sheet submitted, my lord. Lordship may direct us to, my lord, may.
Any interim order? No.
No interim order, my lord. Actually, it was a scuffle between two vendors, my lord, and one of the vendor unfortunately died, my lord. This is the case, my lord. Now investigation has complete, my charge sheet has been submitted as submitted by my learned friend, my lord.
(482) BNSS. Sangsari PS case number 106 of 25 under section so and so, 1052 at Kochi. So the case arose out of an FIR dated 18/5/25 lodged by one Bijoy Das alleging he's the
For his son, my lord, his father,
named accused. No?
named accused, my lord.
No. That the present accused assaulted his father, leading to injuries. Full stop. It appears that subsequently the victim died and section 105 BNS was added. It is submitted by learned additional PP, Mr. Goswami, that investigation is completed, resulting in a charge sheet. In the given circumstances, allowing this bail petition, it is directed that in the event of arrest of the present petitioner in connection with this, he shall be allowed to go on bail of ₹30,000 with one surety, the like amount to the satisfaction of the arresting authority, and subject to the condition that he shall be available for trial, comma, if one commences, semicolon, he shall not hamper or tamper with evidence. He shall not intimidate or harass the informant side or any witnesses. In case of violation, the bail will be liable to be cancelled. The bail petition stands allowed in this.
I am so deeply obliged, my lord.
27 Lordship, also same charge sheet submitted Lordship.
What is the section?
Okay, actually,
Interim is there. No?
yes, Lordship. Petition number in respect of petition number 1, Lordship. There is a Lordship, cross affair also, Lordship, because is a Lordship, sudden fight, Lordship, regarding the celebration of the election result, Lordship, between two parties, Lordship.
27. Proceed this.
Yes, 9 is the affair, Lordship. Yes, 9, Lordship.
Yes. Charge sheet submitted, right?
Yes, Lordship.
You are applying for informant.
Informant.
Make your submission.
Lordship,
Either we can make it absolute or we can call for some records.
interim is granted only one, another remain.
Only one.
Yeah,
Achha,
Lordship.
only one.
Regarding this, Lordship, I have some objection, Lordship, kindly see. Duly sustained by the persons legal.
You can call for the materials also.
Yes, yes,
Can-
TCR.
That will be better, not
Yes, yes,
charge sheet, medical report and CS will do.
yes, yes.
What to do, you know, people fight like this. Here's the last order dated 31/7/25. Petitioner number 1, Sheikh Sadi Ahmed Mikasa, was granted interim pre-arrest bail by that order. Full stop. Is submitted by learned prosecution that in the meantime, this has been charged. Learned counsel, you are Mr. S. Rahman, appearing for the SU Ahmed, appearing for the informant side, submits that he has objections to grant of bail. Full stop. In the given situation, call for scan copy of the case diary, charge sheet, and medical report for better adjudication of the matter. List on the interim bail granted to the granted to petitioner number 1. It will here fight order dated 31/7 stands extended till the next date of listing. You can take the photographs.
Registrable 611.
Registrable from the concerned court.
From the also from the court of the, which will be the relevant court.
CJM South Salmora,
Also from the from the concerned learned court, this learned CJM South Salmara. List, date we have not fixed, 6/11. List on 6/11. Doubtless. Fifty-one. You've got the copy, madam?
Yeah, I've got the photo.
Actually, the matter is more like a criminal petition, but he has filed it invoking this jurisdiction. So it is registered as WP criminal.
My limited prayer at this stage, Lordship, I'm not just challenging the FSL or the DNA test report. Only thing is that it may be conducted again, Lordship, because of the fact of the delay, substantial delay after obtaining the sample, and there is unexplained delay. Because of that, it's a clear irregularity on the part of the conducting authority, Lordship.
We'll make your verbal submissions only, no written. Would you like to file a written?
Lordship, actually, I'm appearing on behalf of senior government and Dipankar Nath. So notice may be issued.
Because, case is at the last stage. So whatever we should decide it quickly. Your name has been shown, no, today?
Name has been shown, Lord. The government advocate is there.
Here was the last order dated 13/10/2025. Learned Counsel, good name please.
MS D. Bora.
D. Bora. Praise that you can accept notice. You can accept notice.
I also have extra copy, Lord.
The petitioner side will serve extra copies upon the Learned Counsel. The name of the government advocate has been reflected in the cause list today. And then you kindly go through the petition. And if you want, you can file a written. If not, then verbally only you can submit. I'll just explain to you. He's seeking another DNA test with regard to paternity in the in the context of a rape case followed by pregnancy and birth. On the ground that the FSL report, which is against him, was submitted 6 months after
The sample was collected.
sample was collected. Of course, some aspects of it are matters of trial, but whatever it is, you make your this thing, then I'll think about it.
Basically challenging the procedure irregularity.
Lease the matter on, you suggested it. Copies you furnish in a day or two. Copy you give.
Yes, Lordship, extra copy also.
After 4 weeks.
After 4 weeks.
Well, no, it can be earlier also, why don't you?
Let's say kindly fix the date.
I think, let me suggest a date, just 15. Take it on 4/11 if possible.
4/11.
Enough time.
Yes, Lordship. Till that period of time, Lordship, this proceeding is
I
there.
think
Back
we
end
have
of,
already passed, I think.
no, the stay order is not there, Lord.
Full stop. Since the grievance raised by the petitioner side is being, accused petitioner is being looked into in this petition. Therefore, further proceedings in this has to be special.
Page number 10, Lordship.
This number, can you help me with?
Page
that?
number 10, Lordship, special POSCO case number 3 of
Special
22.
Poxo case number 3/21, pending in the court of learned additional session judge / special judge POXO, Kasar at Silchar, shall remain state till the next date of listing.
Obliged, Lordship.
The date to do, 4/11.
Highly obliged.
Break it along.
28 also in this case, charge sheet submitted.
28.
Stephen Sangma.
What is the offense?
My lord, allegation is of theft and receiving stolen property, my lord. And of course, my lord, section 21 of Mines and Minerals Act is also there. But that could not have been inserted, my lord, because it should have been complaint based, my lord. As per in view of section 22 of Mines and Minerals Act, my lord. Whereas, my lord, the Nothing has been recovered from my possession, my lord. Only my name surfaced during seizure of some documents from one Mr. Mehfooz Ahmed, my lord. Lordship may kindly see page number 24. Some documents, some bank documents in my name were seized from the residential house of Mehfooz Ahmed, my lord. That is how, otherwise, my lord, my name is not there in the FIR. FIR is at page 21.
You have not FIR name.
No, my lord.
In any case, it is recorded admission. The petitioner is seeking bail in connection with Bopolia PS case number 13 of 25 under section 7. Stop. It is submitted by the learned additional PP, Mr. Gosam, that in the meantime, investigation is already completed, resulting in a charge sheet. That's true. The learned counsel for the petitioner submits that apart from not being named in the FIR, his name surfaced only during seizure of some documents. It is contended that the petitioner, though charged sheet, is innocent. Nevertheless, in view of completion of investigation, I allowed his bail petition, and it is directed that the event of his arrest, connection with this case, 25,000 with 1 cent. Arresting for, subject to the conditions that he shall be available for trial. He shall not hamper or tamper with it. Stands disposed.
Highly approved.
We have not received the case diary 29.
Case diary was called, my lord.
Not received yet.
Earlier twice, 2 occasions, my lord, case diary was called, my lord. Yeah,
Yes,
my
yes.
lord, can you go through my FIR first, man. There is no allegation as such, my lord.
Just a minute. No, the office, is it a boxo matter?
What's the matter, which taken steps, my
Interim clear as well granted by order dated 10/9/25. Sales extended till the next date of listing.
611.
6/11.
I think also petitioner in interim, we have not received the case diary. It's from Bhangagar actually.
It's from Banagar, yes. Get on order, Ramo. His diary is not received. Interim by 16/9/22. 16/9/25. Stands extended till the next date of listing. Same date you want to do?
Lordship.
12/11.
611.
6/11. 6/11. 6/11.
Case diary received. Lordship. Including my first.
There was an amicus, I think.
I was also appointed as
Okay. You engaged private.
Subsequently, you lodged a receipt of the copy you lodged. The client communicated in person and accordingly I will assign the duty to.
Then I will discharge.
Non-appeals for the petitioner side.
Oh,
Non-appeals
non-appeals
for
for this.
Previous cases,
Let him come, we'll hear.
Lordship.
Petitioner counsel is not here. After he comes, whenever he comes, or after 2. Both of you, when both are ready, we'll.
We have not received the case diary.
POXO matter notice was issued, notice served.
6 of POX was there.
Notice has been served.
Notice served. Office notice.
Office notice then.
Report.
2284.
So petitioner is an interim lordship. We have not received the case diary. It is from Lakhimpur lordship.
Case diary not yet received. Issue reminder for the same, the interim pre-arrest bill granted by the order dated 17/9/25 stands extended till the next date of this.
12/11/25.
Lordship, kindly listed on, after Deepavali?
Yes, he's saying 12/11. 12/11, November.
November.
Deepavali,
আগত লাগে তোমাক পিছতে দিছো
It is in November, after, long after Diwali. Diwali is this weekend only. 12/11. I'll take up all the timing matters.
37.
We finished this, only 2 matters are there.
37 charge sheet submitted, Lordship, in this case.
POXO matter.
POXO is there.
Notice.
My pleasure, Lordship. Lordship, here is also POXO 12 is there, section 12 is there.
Service report.
18/6/2025. As per the FIR, the allegation is said to be happen on in the month of February. No date has been given in the month of February. But my lord, if your lordship kindly turn to page 14, I will point out one thing, my lord. In the column regarding the complainant information, name, Tanushree Day, so and so, the date of birth is 23/3/2007. 23/3/2007. So in the month of March, she has become 18 years.
And GPS photographs were taken for record. They also informed that the barricades might have been removed or stolen by miscreants, and that some two-wheeler riders often entered a one-way construction stretch by moving the barricades, especially at night. And other also recorded as Jitu Soikia, his statement also there. Ojit Bormon, Lordship, as per his statement, Lordship. One, Avinash Kumar, by his statement, Lordship. The construction of the drain was almost complete except for the top openings, which were generally left temporarily open for cleaning and furnishing purposes, and opening the holes and covered with plywood sheets, which was done under my direct supervision. On 26/8/25, I again visited the said site and found that barricades were properly installed and plywood cover was securely in place. However, after the accident on 3/9/25, I observed that the barricades were missing and the plywood cover had been displaced and found at this distance. In my understanding, the barricades might have been stolen or intentionally removed. As such incidents frequently occur at public construction sites, the total project stretches of in 3.5 kilometers in length. At which construction activities are being carried out at multiple points simultaneously, continuous round the check supervision at every section is not practically possible, Lordship.
Very well.
All other statements
Last
are there.
enforcement is of what date?
Large entry.
Advance.
Large entry date, Lordship.
Case diary has been received.
We have received the case diary in our 1310 in our office.
Reasonably updated.
13 days of the money.
No, yeah, it did not really have that. We have received on 1310.
The last enforcement case diary, the
Last one, last one, we have very, very not yet.
I'll go through it.
On 1010, last I noticed it.
I'll go through it.
Pyro to my lord.
1010 is the last I note, and 1310 we have received the
Reasonably
case.
updated. 10. Today is 15. Tomorrow I'll pass the order. 10:30.
My lord, one more
Yeah,
thing, my
you
lord.
can complete your submission.
My lord, one more thing I have to place, my lord.
Yes.
Prior to my lord occurrence, my lord, I have lost 2 FIR, my lord, because of the, my lord, the frequent, my lord, theft, my lord, in the night, my lord. So that is, I have already lost the FIR, this is already registered also, my lord, prior to that thing. So all measure in our part, and my lord, also, my lord, there are this, from this company side already, my lord, 3 persons were arrested, all, they are all inside, my lord. These are the one of the
This
directors.
this is only for this person.
I only one person, the director.
FIR lost.
And engineers and my lord, site player, my other persons, site engineer, my lord, they are in jail, my lord.
I have flag marked the
Tomorrow it will be ready.
My lord.
Don't worry, because it will be,
And
it won't be
probably,
delayed.
my lord. And already 41 days, my lord.
I have written down. Note to লগাই থব That's note to লগাই থব স্টেপলাৰ এটা দিলে ভাল হয়।
Diploma.
Tomorrow, 16 term. Next. Could you take instruction in that matter where today was fixed for, this statutory bill if charge sheet is not submitted, 91st day, I think. Huh? I think which matter?
It is pending, Lord.
Ah.
Charge sheet not submitted.
Not submitted?
Not submitted.
You got the instruction?
Instruction, I mean, sample 70/25 South Summer.
Did you?
From our office concern, it was stated that yes.
Which was that matter, item number?
Item number, it was 54. The case I in
No, not 54. Not 54. Your instruction is ready, when council comes, we'll take it. Next. Supplemental.
On the last
your
occasion
matter,
yesterday,
no?
my lord.
So go ahead.
In fact, my lord, you also will see FIR, my lord. Page 10. My lord, if she was, her head was split,
Okay, we had called for injury report.
injury report, but
Remember.
whether it is there or
Oh,
46, I am behind the bar, 46 days, my lord. And my
Uh,
lord, if it, her head was
Injury
split
report, my lord, not received, my lord.
Not received.
4 times, my lord. Today is 46 days.
Today also.
My lord, even she was not admitted in hospital, my lord. And because of my lord, love affair, my lord, there was misunderstanding between. Or she is visiting my house also to taking.
So why, when can you get the report?
My lord, today also I contacted the IO, my lord. He is supposed to, my lord, deliver. He asked me to,
Electronic copy can be sent
electronic
nowadays.
copy, my lord.
Electronic copy, WhatsApp copy can be sent at least to.
At
in case
least
if
at-
the- if-
at
if it
2 I
comes- yeah,
will
if it
again
comes
try.
from the IO's mobile, it will genuine.
Yes, my lord.
Like there was a.
Actually, IO is on leave. He instructed someone to collect the at 10:30.
This electronic mode should
Yes,
be
yes.
used.
Yes,
Try, let us try today only,
At 2.
at 2, yes.
2 or later, second half,
Later or
in the course of the day.
Yes, yes, during the course of the day.
Oblige, my.
No, second half, after he gets the. 84. Before.
Yes, my lord. 54 charge sheet not submitted, my lord. No, charge sheet no.
No, council will have to come because there's
Yes,
opposition from the informant council.
it was one.
Let them come. Round up good here, whatever. These options left over. At around corridor left over, then otherwise we'll proceed to order.
24 and 24.
May it please your lordship. It's an
When-
anticipatory bail application. The FIR is at page 14, my lord. And type copy at page 12, but even 14 is legible, my lord. 14, my lord. On 26/2025 at 9:05 PM, the informant, Sri Rajesh Kumar Agarwala, son of so-and-so, lodged a written ejahat at Jorhat PS to the effect that the accused Gajanan Gaju Munda and Nankishore Mundra took shop on rent in from the year 2007. In and around the month of April 2022, Gajanan Gaju Munda called an informant to his hotel, namely Rajmahal, situated at Gorali, Jorhat. Firstly, it seemed normal to the informant as they used to meet and to discuss any rental related matter. But after meeting Gajanan Gaju Munda, showed the informant some pen drive and started threatening of dire consequences, as according to him, the pen drive contains illicit video and audio clippings, which is out of informant's comprehension. At that period, informant's daughter was engaged and her marriage was due, so the informant got terrified. Taking advantage of the delicate situation of mind, both the brothers forced informant to pay a huge amount of money, that is rupees 47 lakh, only to them. When the informant did not have cash, they even forced the informant to transfer all the money informant had in bank account in HDFC Bank to RD Trading Company, proprietor Nanda Kishore Mundra. The bank statement of those payments is attached with the FIR copy. Informant also said that for the marriage of the informant's daughter, informant was compelled to take money from friends and relatives on loan. Now they are threatening the informant for some more money for last 1 year. Recently, GST department also inquired informant about the huge sum of rupees 47 lakh only in the informant's name, reflecting in the RD Trading's proprietor Nankishore Mundra income tax returns. A photocopy of that IT return is also enclosed. Informant has been duped of all informant's old age savings by these accused brothers and suffering mental trauma. To that extent, informant has lost all hope. Again and again, informant is contemplating to commit suicide, as informant has no wish to live like this. Informant states that if he has to commit suicide, these two persons, namely Gajanan Gaju Munda and Nankishore Mundra, are the actual cause of informant's extreme state. Now, my lord, from a reading of this FIR, my lord, it is clear that the allegation is of 3 years back, and it is only after the GST returns were verified by the income tax authorities that he has come by way of this FIR. Now, my lord, I am neither Nankishore Mundra nor Gajanan Mundra. My lord, my name is Riaz Hussain. The reason why I am before lordships is, my lord, I had gone along with one Parvez Hussain, my lord, a journalist, to the Jorhat police station when Parvez was called. I had accompanied him, and in the police station something might have happened, my lord, for which I had been asked to appear before the police station. I have no role to play here. In fact, my lord, I was given interim protection, and pursuant to that, my lord, I had appeared before the Jorhat police station, and my statement has been recorded by the IO on 16th of July 2025. And this Parvez Hussain had also approached lordships by way of another anticipatory bail application, which has been granted to him. Well, I have a copy of that order, if lordship may like to peruse.
It is here, I think. No, this is not.
Oh, my lord.
This is different.
My lord, here the name is Riaz Ahmed. If lordship comes to page 3 of this order.
Which order? This is
of the order in Parvez Hussain. Lordship Parvez Hussain. Order dated 20/08/2025.
You have annexed?
Not annexed. Lordship said it is here. I have a copy, my lord.
No, not here. I thought this is the one. This is Gajanan Mundra.
No, my lord.
Nankishore. This is Surana Sahib passed in order.
My
10/7. Long.
My lord. My lord.
You have only one copy.
One copy.
No, you read it from there. I'll follow.
My lord. I have another copy. I'll
follow. I'll take it later.
Starts at the second page, the last line, my lord. My learned friend had appeared. Mr. P. Bhattakur, lordship finds it, but last line, second page, last para 5, my lord, last line. Mr. P. Bhattakur, learned additional public prosecutor for the state, has submitted in this regard that there is no such business transaction, and basically it is a case of honey trapping wherein rupees 47 lakh was demanded by showing some video clips, and in the name of settlement, the present petitioner, along with one Riaz Ahmed, also demanded money to the informant. However, it is a fact that all the money transaction through the bank, was through the bank, and the money was deposited in the name of RD Trading Company, the company of the prime accused. However, the present petition has appeared before the so and so. The interim, my lord, the anticipatory bail was granted. In my case, my lord, I have a further submission, my lord. It is, my lord, the case is of 3 years back, and it is only after the income tax authorities, my lord, started scanning, he has come. So it may not be a genuine case, but be that as it may, my lord, I am none of the accused persons, my lord. I am not a name accused, my lord. My name is nowhere to be found in the FIR or anywhere else, my lord.
Anyways,
My lord.
the diary is come.
Case diary received, my lord. Here, my lord, from the contents of the allegation, as my learned friend has pointed out, that regarding allegation between the complainant Rajesh Kumar Agarwala and the other two accused person, Gajanan Mundra and Ram Kishore, and someone other, my lord. And so here how the role of the present petitioner comes in this case, my lord. Well, in this case, my lord, while my lord going through the case diary, my lord, here the allegation is that he has the accused person has received an amount of rupees 47 lakhs, my lord, by showing, my lord, by initially, my lord, they, my lord, showing by way of showing some illicit video and audio clippings. So, my lord, that is the which is out of informant comprehension by showing that video, and thereafter, my lord, this accused person has, my lord, demanded that amount of rupees 47 lakhs. And the present accused person, along with one, my lord, Parvez Hussain, they were actually, my lord, from the note of the IO.
He's Riaz Hussain.
I'm Riaz Hussain.
Riaz Hussain, my lord. They are actually acting as middlemen, my lord, for collecting that amount. That is the allegation, and that is the statement of the complainant. And my lord, his wife's statement is also here, my lord, in the petition, my lord. And otherwise, my lord, only allegation against from the contents of that FIR against the other two accused persons, and the present accused petitioner helps the other two accused persons for collecting that money from the, my lord, informant.
Honey trapping kind of.
Honey trapping, my lord, that is also
Not
because
against
by
the
showing some illicit video, my lord, what is that video? What is there in that audio clipping,
That
for
is
my lord?
seen. Anyway, so.
The money is transferred to a bank account.
I'll see. I had seen this, I think, but this is different. This petitioner is
It is
different.
also a fact that, my lord, those accused persons are the tenant of the informant since 2000.
Investigation has progressed, no?
Investigation progress.
Okay. You give me the case diary, I'll
Yes,
pass the order tomorrow.
My.
And give me my learned counsel and additional PP. Case diary is received. Stop and shall be written.
Interim one of the present petitioner is there. He appeared, my lord, before.
He appeared. The interim bill granted by order dated 14/7 stands extended till the next date of listing. Fixed tomorrow. Today, I think I'll finish early. All the pending matters.
Deeply obliged.
I'm keeping this, huh?
My lord, my lord, I have an extra copy. It's a download. Deeply obliged.
Which one is it? Item number 24. These are particular. Before lunch, I'm going to No, it's a fixed tomorrow. For order, delivery of order. Did you come by timing or
26?
26.
Like these are for lunch.
My lord, 26 is also related to the earlier case, although, my lord, different case registered under different, my lord, but the informant is same, accused persons are also same. Here the
the FIR is same.
FIR not same, different case, my lord. The present case was registered on 14/7/25. After the earlier case, my lord, earlier case was registered on.
My lord, he is placing the earlier case, my lord. Here, my lord, there is no any relevancy with the earlier case. In this, no, my lord. In this regard, my lord, there is a last page, my lord, in the file, my lord. There is an order, my lord. There is an order of the law code below, my lord. That is available. Last occasion I have submit. Last occasion court observed that the FSL report is not available. Case diary was available. And therefore, my lord, this date has been fixed, my lord. My lord, what happened, my lord? According to this, my lord, FIR, my lord, there is allegation is that, my lord, by using a fake documents, my lord, we are running our business since 2026, my lord. And the complainant has raised the objection is that, my lord, by forging his signature, my lord, we are running our business place. And in this regard, my lord, the prime accused who has entered in the agreement, my lord, lordship will find the agreement, that agreement in question, my lord. That agreement lordship will find at page 28 annex 4, my lord. That agreement has been duly signed by the Rajesh Kumar Agarwala and N.K. Nanda Kumar Mundra. Not by the Gordanand Mundra. This is the so this relation has.
Present petitioner is?
Gordanand Mundra. This agreement, my lord, I am reading the only first.
Yes.
My lord. This agreement of the tenancy is entered into this day, first day of the August 2016 between Sri Rajesh Kumar Agarwala, son of late Mahavir Prasad Agarwala, so and so, and Sri Nanda Kishore Mundra, not by me, my lord. And my lord, this agreement has been used to obtain the trade license, my lord. My lord, kindly turn to page 33, my lord. This trade license has been issued. Lordship will find at page 33, my lord. This is the trade license, my lord. This trade license has been issued on, lordship will find the date top of the table, my lord. There is a table, my lord. 16/8/2016, my lord. And continuously, my lord, this trade license was renewed before the municipality board. I have annexed all documents. And lastly, my lord, he has raised an objection regarding that particular trade license, my lord. In that trade license, and after getting the objection, my lord, the municipality board Jorhat, my lord, stopped to issue the renewal the trade license. In this regard, my lord, we have approached the honorable this court, my lord. And this court also will find at page 37, my lord. Annexure 6, my lord. And this court has passed an order directing the municipal authority to take the hearing. Already hearing has been taken, my lord. And this is on pending. And there, my lord, they have the complainant stopped to receive my rent, my lord. While in the year of 2024, my lord. From my lord, date of July 2020, my lord, this is the Salan, my lord. From the July, my lord, May, my lord, we are starting to make the payment before the court, my lord. All the payment slip, my lord, that will lordship will find at page 40, annex 7 series, my lord. We are not the defaulter, my lord. Till date, we are not the defaulter, my lord. We are paying before the court, my lord, his rent of the house so proved. While, my lord, this FIR has been filed, my lord, lodged before the police, the Nandakishore Mundra was arrested. On 14, my lord, FIR was lodged. On that day, my lord, Nandakishore Mundra was arrested and produced before the court. And lordship will find what happened in the court, my lord. That order I have annexed, annexure 9, page 56, my lord. On 16/7/2025, my lord, he was produced before the court, and on that day, my lord, the Nandakumar Mundra moved with an application for the bail. Lordship kindly turn to page 64. I am reading the relevant portion. And court on that day, my lord, interim was page 664, my lord. Relevant portion.
It was allowed, right?
Yes. And thereafter, my lord, case diary, after perusal of the case diary, my lord, interim was granted on that day, my lord. On 16, interim was granted. Interim was granted and fixed on 22, my lord. 23, my lord. On 23, my lord, that order is there, my lord. Kindly peruse that order.
Absolute.
Made absolute, my lord. While it is absolute, my lord, court was observed that court observed that in the third page, my lord, the fourth page, my lord. Perusal of the case diary reveals that the accused has submitted the tenancy agreement dated 1/8/2016 to the investigating officer, and investigating officer has taken specimen handwriting and signature of the informant and the accused person. It is appeared from the
case diary that the informant submitted one application before the officer in charge, Jorhat Police Station against the accused so and so, so and so, so and so. However, perusal of the case diary reveals that the investigating officer has not made any investigation as regard the allegation made in the said application. Another application was filed. I have also gone through the statements of the witnesses recorded by the investigating officer. No other elements have been found regarding violation of bail conditions imposed on the accused while granting interim bail. Considering that the impugned tenancy agreement has been seized by the investigating officer and specific handwriting and signature of the informant and the accused have been taken by the investigating officer, and considering other attending facts and circumstances of the case and having regard to the contention of both the side, I have not found the ground to custodial detention of the aforesaid accused. Accordingly, prayer for the granting bail of the aforesaid accused is allowed. Interim bail granted to the aforesaid accused person is made absolute with condition so and so, so and so, so and so. My lord, already Nanda Kishore Munda, with whom the agreement was executed, my lord, already, my lord, he has got the bail, my lord. I am already the sibling brother, my lord. I have no relation with that particular business, my lord. Since he has got the prime accused has got the bail, my lord. And I am in interim, my lord. I was appear before the IO, my lord. My handwriting, my specimen signature, my all statement has been recorded, my lord.
Just a minute. What you were saying about the connection
yes.
with the other case, it's a different case.
Because this is, case is different, but informant is same. And accused persons are also Gajanan who are the
It's a different dispute.
different dispute regarding that manipulation of that tenancy
Yeah,
agreement.
no.
That is, he, in this case, he appeared statement recorded.
This also let me pass
Uh,
together on
yes,
so tomorrow.
yes.
Go through it. But learned council, issue case diary is written.
And
Interim
this
bail passed on 24/7/25, so continue with the next date of list.
earlier case was registered on 26/25. The present case was registered on 14/7.
So that's why
Earlier case has no relevance. That is total
they are different dispute, same parties.
party is the same, my lord.
It can be different dispute can be between same parties also. List tomorrow for delivery.
Yes.
Tomorrow I'll deliver it.
My lord, I am appearing. My statement has recorded, my lord.
Yes, so that I have noted down. It will
Statement is
Yes, submitted also.
Bail
Yes,
bond is
submitted
there,
also.
man.
bail bond is there.
That law.
Okay, chalo.
দুটাই বেলেগ বেলেগ other time being statutory matter, no?
As per instruction from our office, Lordship, search is pending.
Huh?
Search is not laid down.
No, not
It's pending, Lordship.
The I.A. Chaudhary, Learned Counsel, and D.P. Goswami, additional PT. Someone was appearing, huh? Someone was appearing for the, but this is statutory bill, but we should
Yes.
inform him, you know, just inform him once.
Yes.
Inform him. The accused petitioner, Mohit so-and-so is invoking 483 BNSS. Seeks bail in connection with South Salmara PS case 78 of 25 under section so-and-so. Pursuant to appearance of, issuance of notice upon respond number 2. Learned Counsel has appeared on his behalf, entered appearance on his behalf. The accused is stated to have been arrested on 16/7/2025. Today is 91 days.
91 days.
91.
And as on today, has completed 91 days in pre-trial detention full stop. Learned additional PP upon instruction has submitted that investigation is not yet complete. In the said situation, the accused has become entitled to default bail. According, is allowed to go on bail of rupees 30,000 on surety of the like amount to the satisfaction of the concerned Lanet Court, which is Special Judge South Salman. Special Judge South Salman. And subject to the conditions, he shall be available for trial if one commences. Number 2, he shall not hamper or temper evidence. He shall not intimidate or harass the informant side or any witnesses in violation will to enter cancellation of the bill. This first of all. Sixteen. Oh, if you're ready, we can take up 17.
Maybe after sometimes, madam.
My lord, this Lanet Amicus, he's on another court, my lord. Maybe he's coming, my lord. The way, 17, my lord.
Only 5 minutes, we can do some
Yes, my
small
lord.
matters.
18, my lord, 18.
Mr. Ahmed is also not here.
Maybe.
Might be busy. What were the
As per my instructions, search sheet not yet submitted, my lord, in
Which
this
one?
case. Item number 4, my lord. Today is, my lord, 60 days, my lord, mandatory period for filing search sheet, my lord. 60 days is already over, my lord.
Today is 60 days or 61st day?
Yes,
61st day?
yes, 65.
No, Mr. Gailo always used to use date calculator. So use a date calculator.
Today is, my lord, 64th day, no?
Calculator.net, our website has date calculator. No. Then,
Today is, my lord,
12 date.
19. Today is, my lord, 64th day, my lord.
64 days.
Yes, my lord.
483 bill application, Patasar Kusi PS case number 155 or 25, so NDPS Act. He was arrested on 12/8/25. And forwarded on the same day. Forwarded for remand on the same day. The learned additional PP submits that investigation is not yet completed. In the meantime, the accused, having completed the applicable statutory period of 60 days, has become entitled to default bail according to the 30,000 with considerate. Third condition to inform he shall not indulge in any illegal activities or offenses. This was
Yes,
64 days, no?
64 days.
May I plead your lordship? FIR is on page number 13, 13.
At page
13.
Which section is that?
Section 12 of,
POCSO.
POCSO, punish.
Bail petition is not maintainable, it's dismissed. Because of the bar. Time being.
My senior is on left, Lordship. Kindly.
Yeah.
Page 16.
Here, this is registered under NDPS Lordship, but my main ground is Lordship that at the time of arrest, he was not informed about the grounds of arrest, Lordship. That your Lordship will find page 37 onwards.
Commercial quantity.
Commercial quantity. It was recovered from the bank of the pond, which is situated near his house.
Bank of the
Pond.
pond,
Pond.
which is situated in his
Yes.
compound.
Compound. That is an open place. Page 37, that notice. Under section 15,
We
no
have to
ground.
say that then.
Yes. Page
He was
30.
arrested on
He was-
23.
Yes, 5/11/23.
This is the notice.
Yes. Page 37.
What do you have?
Yes, my lord.
Same.
My lord, I have gone through that, my lord. So, my lord, arrested on 5/11/2023, my lord. And my lord, contraband is 21 kgs of ganja, my lord, recovered from his residence. Whatever
some
may
of
be,
the-
now, my lord, only on the ground of arrest, my lord. Only on the ground of arrest, admitted position is that, my lord, section 50 and 50 notice, my lord. There, my lord, I have flag mark, my lord. There is no written ground of arrest is there. But, my lord, that is for the, my lord, other region, as per, my lord, Bihan Kumar, and after Kasi Reddy, Upendra Reddy, and subsequently, my lord, that is the Darshan's case, state of Karnataka versus Darshan, my lord. Now, my lord, that ratio has to be find out whether, my lord, the objective of the notice, whether when he was, my lord, produced before the learned, my lord, JMFC, my lord, whether at that point of time he has taken the plea, my lord, that is the defense or not. My lord, that order is not available with us, my lord.
Which order?
My lord, because, my lord, he was arrested on 5/11/23, but, my lord, that is the, whenever he was produced before the learned JMFC, my lord, that order was not available with us, my lord.
So probably that order is not required because Darshan, which my learned friend is relying, that is clarified by division bench of our High Court. In that case, Lordship, it is said that even Darshan's case also says that that it has to be communicated to the accused, Lordship. That criminal appeal number 234 of 2025.
My lord, that
Yes.
matter is related to NIA, my lord.
Yes,
What is
I'll-
my learned, what my learned friend has stated, my lord. And there, my lord, regarding the service of the notice of the 48, here, my lord, it is a case, my lord, compliance of both the notices are there. Only, my lord, that the question came in the case of my lord Bihan Kumar, the Prabirupur Kayastha, Bansal, the whether, my lord, in the written mode, the communications were there or not,
So
my.
this notice is, you are hereby informed that you are arrested.
Yes, my
It
lord.
Used to be given like this before.
My lord. But,
given-
my lord, that is the
50
in the written format, the grounds were not there, my lord.
50A is there.
50A is also there, my lord. 50 is also there, my lord. My lord, I have flag mark, my lord, in the, my lord, in the, my lord, TCR, my lord.
It will be
In petition
Scan
also
copy of the
35
TCR.
copy is there, page 38. 50A.
আমি এটা order লিখিছিলো কালি এটা আছিল যদি দিয়া হয় তেতিয়া সেনেকে লিখিব লাগিব তাত হেৰি দিছিলো মই
And, my lord, here is a case, my lord, because, my lord, on this point, my lord, this argument was, my lord, made, my lord. I am not, but otherwise, my lord, earlier occasion also, my lord, a bail petition was moved, my lord. But that was, my lord, rejected by the, my lord, that is the special, learned special judge. As because when he was a UTP, my lord, at that point of time also, he was, my lord, again shown arrest in another case because in the central jail, my lord, he was, my lord, doing the act of the peddler, my lord, heroin, my lord. So that is another, my lord. I have flag marked those also, my
many
lord.
cases we are having
My
to
lord.
give bail because on applying these principles.
My lord.
If the law.
Only, my lord, my submission is that, my lord, to find out that ratio, my lord, whether, my lord, demonstrable prejudice is there in the side of
This
the,
will
my
not
lord,
do.
accused or not, my lord.
This notice will not do. That is
My
a
lord.
fact. This notice
So,
will
my
not
lord,
do.
my lord, I am, my lord, my lord, relying on the, my lord, the production order, but that production order is not
No, he
available
was
with
not,
us,
he
my lord.
was, he was not shown arrested in this case.
No,
He
No,
was
not in
arrested.
this,
He was,
not in this case. When he was in prison, my lord, that time, my lord, in another case.
He's lucky that the commercial quantity is very difficult otherwise. But anyway, stringent conditions have to be imposed. Yes, main thing is the trial.
Main thing is the trial, my
The
lord.
prosecution can conduct the trial properly, then it's, you will face it. Otherwise, this law has to be followed, right?
Yes.
This is the scan copy.
Yes, my lord. My lord, there, my lord, the order of production was not there, my lord. Whether, my lord, on that day, my lord, he engaged any counsel, my lord, from his relative, that was not reflected, my lord. If he was, my lord, defended by his counsel and a bail petition was moved, my lord, then the, my lord, that is the, what in the Darshan's case is stated, my lord, that is, my lord, fulfilled, my lord. Or my lord may kindly call that, my lord, that part of the order.
Same bench, no, division bench is clarified actually.
Yes,
We have to
that is
follow the
why I
earlier
think-
order, earlier judgment, but this thing is still, it's in process.
My-
More clarity will come in the
My-
coming days.
Some judgments are.
It will come, more clarity will come, more clarity will come.
Yes.
Honorable Apex Court is, I think, surely aware of this thing. More clarity will come, perhaps from a larger bench. Anyway, for the moment, we have to just follow whatever is there. Invoking section 483 of the BNSS, the present accused who was, who's in custody since 6/11/23 is seeking bail in connection with sessions, NDPS case number 19 of 24, within bracket, rising out of Hajo PS case 639 of 23. Under section 20C 31/31 of NDPS Act, and pending before the learned additional session judge Kamru Aminga. The allegation in the FIR is recovery of approximately 21 kgs of suspected ganja, cannabis ganja, from near a pond of the pond in a compound of the accused, compound of the house of the accused. Good stuff. Has it, trial has started?
Charges were framed, but as per my instruction, lordship, that charge framing order, I have also enclosed case 20.
My lord, my lord, the PW3 is examined on 9/7/2025, my lord.
Scan TCR as called for has been received. Good stuff. Pursuant to framing of charges, the case is at the stage of trial, and some witnesses have been examined already. The petitioner, Mr. Ahmed, petitioner counsel, primarily basis his contentions on non-compliance with the statutory notices under 50A CRPC at the time of arrest. Copies of the same has been annexed with the petition. The same is also available in the scan TCR. Both notices were furnished, but the contents thereof are as follows. Uthai দিব, content, it's same. We'll go forward. Just এটা part of headline 52. What are say? Any contents still similar. It is well settled by now that in terms of the law laid down by the Honorable Supreme Court, in the case of Prabir Purkasto and Vihan Kumar, dash, that is a full citation, dash. Detailed grounds of arrest have to be furnished to the accused at the time of his arrest, and such grounds have to be specific at the time of his arrest to the accused and to his relative, and that such grounds of arrest have to be in reasonable detail and also specific in nature to the accused. Full stop. Full stop. Failing the same, comma, there would be a fatal procedural infirmity in the arrest, comma, making further detention untenable, and hence entitling the accused to bail. In view of the aforesaid nature of the notices, clearly they do not fulfill the stipulations laid down by the governing law. And therefore, despite the rigors of section 37 NDPS Act, the present accused has to be granted bail. Full stop. Accordingly, 50,000 with one surety of the like amount. One is only one, 50,000 with one surety of the like amount. The satisfaction of the concerned learned court, additional session judge Kamrup Amin, and subject to the following conditions. Number one, he shall be available for the remaining trial. Number two, shall not hamper or tamper with evidence. Number three, shall not try to influence witnesses. Number four, shall not indulge in any activities of consuming or peddling narcotic drugs. Full stop. In case of violation of bail conditions, the bail would be liable to be cancelled. The bail petition stands disposed of. Take it. This is for you. This is for you.
No, my lord. This is a part of the
Part
court.
of the
record.
Nicely tagged. Very nicely tagged. Please come. All other arguments are complete. We're just waiting for your permission.
Lordship, I'm for the informant, Your Lordship.
Yeah,
Here the allegation is very serious, Your Lordship. So because Your Lordship, a minor girl persistently committed rape on.
But the said application was rejected by this honorable court. No order has been next. I place the order before your lordship. Same ground was taken in that application. Lordship may come to paragraph, first paragraph 5.
As paragraph 5.
Married lords. It is contended on behalf of the petitioner that while submitting the final complaint charge sheet in the case diary by the DRI, it did not submit FSL report of the allegation of NDPS items seized from the possession that the DRI only on 28/11/2024 submitted the relevant FSL report before the court. That is after 295 days of his arrest. According to the petitioner, the statutory period of detention in custody is 180 days. And due to non-submission of the FSL report by the DRI along with the final report, he is entitled to default bail after 180 days from the detention since 10/3/2024, and that he is wrongly detained in the custody. So same ground has been repeated here. Lordship may come to paragraph 14 to 20. Married. Paragraph 14. Considering the decision of the Calcutta High Court in case of Idul Mia placed on behalf of the petitioner and the decision of the coordinate bench of this court, as well as the order of the Honorable Supreme Court in special leave application number so and so noted above, the court found that
Order to, yeah.
paragraph 15, that the court found that it is not the case of the petitioner that substance recovered from the petition while being tested during the time of seizure by using field drug testing kit did not give positive result for the morphine. The only objection of the petitioner is that while submitting the final charge sheet in the court, the FSL report was not filed along with it, which was submitted subsequently after 180 days of detention of the petitioner, for which he is entitled to default bail. Paragraph 16, it is seen that altogether 2015 gram of morphine was recovered from the possession of the petitioner. According to Mr. So-and-so, DRI has valued rupees 10 crore 7,50,000 in the open market. Paragraph 7, on perusal of the order dated 1924 of the case in the Hanif Ansari Supra, it has been held by the Honorable Apex Court that the amounts amongst other consideration, it is earlier decision of the case of Central Bureau of Investigation versus Kapil Vadan and another reported in 2014 INS 58 that that dealt with the question of an incomplete charge sheet, and it is impact on the bail plea of the accused, where the Honorable Apex Court held as under. Once the material produced along with the charge sheet, the court is satisfied about the commission of offence and takes cognizance of the offence allegedly committed by the accused. It is immaterial whether further investigation in terms of section 173(8) is pending or not. The pendency of further investigation qua the other accused or for production of some document is not available at the time of filing of the charge sheet would neither vitiate the charge sheet nor it would entitle the accused to claim the right to get default bail on the ground that the charge sheet was incomplete charge sheet, or that the charge sheet was not filed in terms of section 173(2) of the CRPC. Paragraph 18, considering the entire aspect of the matter, decision of the coordinate bench of this court in case of Adris Khan, Jitu Lali and Motiur Rahman, as well as the order of the Honorable Supreme Court in case of Kapil Vadan and Hanif Ansari, Supra, the court found that the submission of Mr. Kyal Learned Counsel DRI has force. Court also found that 2015 gram of morphine, a scheduled NDPS item, much more than the commercial quantity, was recovered from the possession of the petitioner. Further, the learned trial court has already framed charge under section 21C of NDPS Act against the petitioner for recovery of 2015 gram of morphine from its possession. 19. For the reasons above, this court is opinion that the petitioner is not entitled to any such benefit of statutory default bail for not submitting of the SFL report while submitting the offense report charge sheet in the case that it was filed within the statutory period of detention of the petitioner, or particularly finding that the time of seizure from the possession of the petitioner while testing the seized substance using the field drug testing kit, the said seizure substance gave positive result of morphine, a scheduled drug and NDPS item. As such, the detention of the petitioner in custody since 10/3/2024 cannot be considered for his bail in the said NDPS case number so and so, arising out of so and so, presently pending before the court of so and so. Accordingly, the bail application of the petitioner named Sajun Rasid, son of Hanwar Rasid, is rejected accordingly. So, Lordship, the point raised by my learned friend in this application was already decided by this honorable court. And
So
Lordship,
either, so I am bound to follow it, and
Yes.
if I disagree, it has to be referred to a larger bench.
Lordship, another,
Please, before Honorable Chief
Lordship
Justice.
has seen that in paragraph only the petitioner has mentioned about
Before going
presumption of
further, just let me see one thing. This Kapil Wadhwan case.
Yes, sir.
The relevant para is this, which has been reproduced. Let
Lots.
me have a look at once the material satisfy the commission. It's material whether for the pendency of further investigation, or production of some not documented matter of issue of a charge sheet, and default bail on the crown, incomplete charge sheet. It's not filed in section. In my opinion, here, the situation is slightly different in this case, the Kapil Wadhwan, because it is about further investigation, that something has been
Lordship,
submitted.
Lordship,
And
here the
document is not, say, this is the Kapil Wadhwan, this judgment, these principles which have been reproduced here, this will be more applicable to case of a sanction,
No,
as
Lordship,
we had
he-
discussed that.
No, here, Lordship, here what happened, the petitioner taken ground in the earlier bail application, that same ground was rejected by this honorable court.
Okay.
And this judgment I am placing, Lordship has seen in paragraph 11, only rejection of the bail has been rejected. Why it was rejected, nothing has been stated. Paragraph 7, Lordship, paragraph 8, 7 and 8 of this judgment. May I read, Lordship?
Rejected order.
Of this judgment.
Yes, Lordship.
Before going further, what was that Hanif Ansari case? What
Hanif
was
Ansari,
later?
Lordship, I am having this judgment with me.
Just a minute.
What's the matter has been referred to full bench by the honorable Supreme Court, Lordship.
Hanif Ansari, what was laid down?
Lordship,
There
nothing
is
else.
also a judgment of UP about whether,
No.
what can be constituted completed charge sheet. We'll come to that, but I am not remembering. Hanif Ansari, you have the copy?
Lordship, that point has not been, that was raised in earlier bail application that was answered by this honorable court. Whether second time they can raise, and in bail application, Lordship, nothing has been stated, no order was annexed. So this is a suppression of material facts from this honorable court. For this purpose, I am submitting.
This one, Hanif Ansari.
No, this is Hanif Ansari, Lordship.
You want, I should look into this one?
Lord,
The
for the.
Usha Daruka,
Yes, Lordship.
that contempt, no?
Yes, contempt.
Okay.
Paragraph 7 and 8, Lordship.
Okay.
Married Lords. It was held in the judgment referred to above that one of the two cherished basic value of the Indian society of centuries is Satya, truth, and the same has been put under the carpet by the petitioner. The truth constitute an integral part of the justice delivery system in the pre-independence era. However, post-independent era, period has been drastic change in our value system. The materialism has overshadowed the old ethos, and the quest for personal gain has become so intense that those involved in litigation do not hesitate to take shelter of falsehood, misrepresentation, and suppression of facts in the court proceedings. In last 40 years, the value have been gone down, and now a litigant can go to any extent to mislead the court. They have no respect for the truth. The principle has been evolved to meet the challenges posed by new breed of litigants. Now it is the well settled that the litigant who attempts to pollute the stream of justice, or who touches the pure fountain of justice with tainted hands, is not entitled to any relief, interim or final. Suppression of material facts from the court of law is actually playing fraud with the court. The maximum suppression of very express falsity, that is, suppression of truth, is evident to the expression of falsehood get attracted, is nothing but degradation of the moral value in the society may become because of our education system. Now we are more happy to hear anything except truth, read anything except truth, speaks nothing except truth, and believing anything except truth. Someone rightly said that lies are very sweet, while the truth is bitter. That is why most people prefer telling lie. Then paragraph 8. The facts of the case has been narrated. Lots of material facts were suppressed from the court. Let's say ultimately paragraph
20.
20, 23, and 24. This is, in our opinion, to avoid the confusion in future, it would be appropriate to mandatorily mention in the application file for grant of bail detail of copies of order passed in the earlier bail application filed by the petitioner, which have already been decided. Here, Lordship, petitioner has mentioned about only rejection of bail. Nothing has been stated why the bail has been rejected, and the order was also not annexed. Then 2, details of bail application filed by the petitioner, which is pending either in any court below the court in question or the higher court, and the none is pending. A clear statement to that effect has to be made. The court has already directed by order passed in
Good directions.
Sadhani Jani so and so that all the bail applications filed by the different accused in the that is not required. Lordship, then paragraph 20, 21. Our suggestions are with a view to streamline the proceedings and avoid anomalies with reference to the bail application being filed in the cases pending trial and even suspension of sentence. 22. Though the considering the conduct of the petitioner, one of the options available was to cancel his bail. However, we do not propose to take such an extreme step in the case in hand. However, this can be an option to exercise by the court if the facts of the case so deemed, seeing the conduct of the parties. 1023. The present appeal is accordingly dismissed as infructuous. However, still we deem it appropriate to burden the appellant with a token cost of 10,000, which shall be deposited by him with the so and so so and so. So Lordship, he had seen the statement, what statement has been made.
No, the rejection, the earlier bail application order has been annexed.
No, nothing yet.
No, it has been annexed
Where?
as annexer 9. I have seen this actually, and I forgot to ask her, but I have seen, I just flipped through and saw it, but I have not read in detail. Now I have read in detail with your help.
Yes,
and help. Right?
Lordship, now Lordship, again Lordship, this point
No,
has already been decided by this honorable court.
In a way, res judica.
Definitely. And Lordship, this facts has to be placed before your.
But subsequent bail petition, new grounds. Okay.
New ground.
What is our new ground?
No, Lordship, only same ground.
Same ground.
Same ground has been taken.
We were discussing that day. Could you find your team find any Supreme Court decision?
Lordship, that is the judgment. Lordship, the matter has been referred to full way. Larger bench.
Are you concerned?
Yes, Lordship.
Let us
Because
have-
Delhi High Court has rejected the bail application.
The different high courts, there is no authoritative judgment of Honorable Supreme
No,
Court.
Lordship.
Oh, it will come.
Only Badwan case is there where it stated that once charge sheet has been filed, it cannot be said that it is an incomplete charge sheet.
Because this, you kindly see this UP judgment, and Mishra, this, there, you know, it is not a very long principles, not a very long
regarding.
It has been, what constitutes a completed charge sheet? Now, one of the things which has been said, I think, is that it depends on the nature of the case. In an NDPS case, the problem is that we'll continue. You will continue. In an NDPS case, the problem is that suppose you are an IO or I am an IO, and I have to file. Under which section I will file? Suppose I want to file under Ganja, because everything, 20 is Ganja, 22 is, heroin and all that. So what is the nature of the contraband? I need some evidence on that, right? Will a drug testing will be sufficient to file a charge sheet?
In my.
This is the
because
question.
Different high court says. Fine.
I'm not expressing any
Lordship,
opinion.
this is a drug testing report. It then initially says when the contraband ceased. Lordship, the purpose of SFL report is to convict the accused whether the nature of the contraband is falls under the NDPS Act or not.
Because see, the thing is that another aspect you kindly think about, that suppose if the drug testing kit, suppose, it is a drug, very good, they must take a drug testing kit, even at that stage person should not be, suppose they seize bhang, that does not come under NDPS. Suppose they must have the drug testing kit.
Definitely.
So, otherwise the person is being arrested, he is being prosecuted. But if the drug testing kit report is suppose taken as final.
No, this is not a final.
No, suppose it is taken as final for the purpose of filing a charge sheet, then it will not be necessary to have a forensic,
No, Lordship, because the purpose of obtaining a FSL report is to confirm, and that is eventually value. This has not a evidentiary value, but for the purpose of investigation, Lordship, this can be taken into consideration. This is the.
And how will the court take cognizance? The court also has to be, because.
No, Lordship.
That somehow, you apply the logic.
That,
if I am not sure, as an investigating officer, if I am not sure whether it is heroin or cannabis or, ganja or hashish, because they are for different, NDPS peculiarity is this, unlike other section, PC Act, this will not bother you so much, but NDPS peculiarity is that for different substances, there are different sections.
Lordship, that's why matter has been referred to full bench.
I will be wrong also.
Now, this is that for this purpose and lots of for the purpose of investigation. Lordship, sometimes we get the FSL report after more than a year. Whether
that is, people are getting statutory bail only because of the FSL.
Yes, Lordship. That is
true. Unless we have a fast track, fast track method, some special laboratories dealing only with NDPS samples, this will continue.
And Lordship, our High Court in 3 cases considered this aspect of the matter. Lordship, I am placing this. These are 3 judgments passed by our High Court, where Lordship, this plea was taken and they filed application for default bail as the FSL report was not submitted to filing the charge sheet. In both the 3 cases,
It was rejected.
that was negated, and court said that yes, if it is initially examined through drug detection kit, then it is sufficient
For the purpose of filing charge sheet.
for the filing charge sheet and take cognizance. Details has been discussed in all 3 judgments.
Okay.
And here in this case, Lordship, petitioner suppressed the material facts by not producing all these things before a Lordship.
No, she has annexed. This cannot be.
But in paragraph, Lordship,
It
nothing.
would be
has been
unfair
written.
to say that.
Lordship, as
The para is also there, annexer 9 is also.
no, Lordship, may please to see.
But in the argument, she has not harped on that. She has not referred to this in the argument, but it has been annexed.
Lordship, may please to see the petition. This was the, Lordship, no annexure has been made.
In the petition,
Yes, Lord.
para 11.
Nothing has been annexed, Lord. Into survey.
No, this is her petition only.
Only Lordship statement has been made, that is not full, details have been given as dictated by the Honorable Supreme Court.
Para 11 is not there, para 11.
It is there, Lordship, but no annexure has been made.
Oh, so they have written by hand
Yes,
later.
in my application, Lordship,
Not
it is
there.
not there.
It was furnished, they have written by hand.
That's why I, Lordship, I made
Against
this
some
on-
nine, but it is here.
But
Because
this is,
I saw it during the hearing actually.
this
It's
is the
not-
application submitted to me, Lordship. Nothing
This
is.
will any case require some, I'll have to study it properly and then.
And Lordship,
But-
my point before you, Lordship, is that this point was already asked in earlier
Not-
application.
Nothing to be decided now.
That cannot be, already it has been decided. And regarding Lordship merit of the case, contravened is received from the conscious position of the petitioner. On 2 occasions, PW was present, Lordship, but he could not be examined. So it cannot be said that there is an undeniable delay. So that point is also against the petitioner.
Ma'am. The application is.
Honey judgment I have given to a Lordship, that order passed by knowledge of Congo. And Lordship, I have checked up, till date, no order has been passed by full, larger bank Lordship.
On merits, there are many materials, no doubt about
Lots.
that.
And regarding default bill, that cannot be taken as a ground now. right?
Huge quantity was seized.
No, that is.
Right, allegedly seized.
Yes, Lord.
The value is said to be 10 crores.
Yes, Lord. Morphine is a very
Yes, yes.
expensive, costlier drugs, Lord. Much of like.
This will be, let me make it savvy.
Lots.
No, because not be, it will be not, it will be not very difficult. It will very cool, no? A. Medhi, learned counsel for the petitioner, addresses our arguments. Also heard C. Kyle, assisted by M. Dekal, learned counsels, appearing for the
DRI.
DRI. Judgment / order is reserved.
Much of.
Don't take much time, but I just work on it. Yes, I got. I don't think 54 and 50, 54. Hold.
55. I think my learned friend has got that.
You have been wait.
Yes.
You
I have
to wait a lot, sorry.
injury report received, Manu.
Finally.
Only thing, my lord, they are in fact relationship, and because of some misunderstanding, my lord, that incident took place, and he has got the lesson, my lord. 46 days behind the bars, my lord.
He has been beaten,
Yes.
but not like what has been said in exaggerate. Let him go. No problem. First page after here, last order, 1410. Stop. The case arose out of FIR dated 30/3/2025. It is alleged therein that ... কিছু প্রমাণ ধরেনি। Stop. The case diary has been received along with injury report. Stop. The injury report indicates bruises and abrasions, but injuries are categorized as simple caused by blunt object. Full stop. The accused was arrested in this case on
31st August.
31/8/2025. In the aforesaid facts and circumstances, and also keeping in mind his length of under trial detention, dash rather, that he is hereby allowed to go on bail of rupees 25,000, okay? With one surety of the like amount, to the satisfaction of the concerned learned court, which is
Kamrup Metro.
Kamrup.
CGM.
CGM.
CGM
CGM.
Kamrup Metro.
Within brackets, CGM. And subject to the condition that he shall not hamper or tamper with evidence. Number two, he shall not harass, threaten, or cause any harm to the informant or her family. In case of violation of bail conditions, the bail will be liable to be cancelled. Okay. Return back is there, bail petition stands disposed of. He sent you by
Yes.
WhatsApp.
WhatsApp.
Nowadays, we have to use all these things.
Deep view. Possibly fix any date, Lordship. My signature was there, Lordship.
Also,
Lordship, in this case, Lordship, he was arrested, Lordship, on 17/9/25, on Lordship, 1/5/2025.
You can, you want to do it? You can do it. You want to do it?
Lordship.
Yeah, you're good,
FIR,
you're a
Lordship,
good counsel.
FIR will find page 14, Lordship.
No problem, everyone can, you're doing well. Page, Yaba tablets. no?
Yava
From-
tablets, Lordship.
Just a minute.
7,661
Yeah,
numbers of
refresh.
Yava tablets, Lordship. And total weight, Lordship. There it, Lordship. With reference to the subject cited above, I have the honor to state that on 30/4/2025, I along with staff headed towards Balukdugi near Law College for Naka checking duty. And during Naka checking at around 5 PM, one motorcycle bearing registration number so-and-so was intercepted, which was coming from Makli towards Valpara Road. After thorough checking, their motorcycle found total 7,661 numbers of Yava tablets suspected to be drugs and recovered from their possession. In this regard, two numbers of persons, it is Lordship Jahidul Islam and Johirul Islam, Lordship, were taken into custody for further investigation. The entire matter was brought into the knowledge to the SP Valpara, and after obtaining verbal permission, all the procedure of NDPS Act have been followed. During court interrogation, the accused person stated that they have brought the bag containing Yava tablet from one Nijamuddin, Lordship. He is not yet arrested, Lordship. Nijamuddin of Jaipur. Accordingly, the local witnesses, namely so-and-so, were present at this spot at the time of seizure. The seizure exhibits were sealed, measured, and weighed the spot. The seized exhibit entered into the PS Malkhana and handed over to the OC PS for registering a case. Lordship, seizure list, Lordship, will find page 15, Lordship, type copy is there, Lordship. Point number 7, Lordship, description of article 6, Lordship. Lordship may peruse the paragraph, Lordship, 6, Lordship, I have stated in my petition, Lordship, page 6. Paragraph 6, Lordship.
This Nizamuddin is not
Not yet,
except arrested.
not yet arrested. As on today, Lordship, 167 days, Lordship.
Case is at what stage?
Charge sheet submitted, Lordship, as per my instruction. LCR received.
LCR has come.
My lord, TCR received, my lord, in this matter, my lord. My lord, here, my lord, the case is that, my lord, the date of incident is 34/2025. And accordingly, my lord, FIR is lost on 1/5/25 and they were produced, my lord. Now, my lord, here, my lord, 7,661 numbers of Yaba tablet that is recovered, my lord. Now, my lord, that is the place of occurrence. It is the Nakasaking, my lord. It is from the Nakasaking in a bike, my lord. In a, my lord, motorcycle. These two, my lord, accused petitioners, my lord, were on the bike. And from them, my lord, from a polythene bag, my lord, the contrabands were recovered, my lord. That is the case, my lord. Now, my lord, as on today, my lord, 169 days. Though, my lord, police, my lord, filed a search sheet, my lord. But, my lord, that is, they, my lord, yet to, my lord, file the FSL report, my lord. Because that was not collected, my lord. In this regard, my lord, a petition was, my lord, filed before the learned special judge on, my lord, 31/7/2025, my lord. I have flag marked that, my lord. Is a horizontal flag mark is there in the TCR, my lord. So that is, my lord, and as per the prayer made by the investigating agency, 180 days from the from 31/7/2025, that was extended, my lord. So, my lord, though, my lord, the CS is filed till date, my lord, yet, my lord, from the record which is available to us, my lord,
Extended.
that has not come to my notice that, my lord, my lord, FSL report is filed, my lord, but that is not available with the record also, my lord. And, my lord,
It has
regarding
been, the period has been extended.
period has been extended. My lord, may I kindly produce the order dated
It was
31/7
extended before it expired.
before it expired.
Application was filed.
Yes, my lord, that was filed, my lord.
Application has to be filed.
Application was filed, my lord, that was extended, and thereafter, my lord, that is CS is filed on 31/8/2025, my lord. But, my lord, that is, my lord, they in the, my lord, I have flag marked that portion also in the search sheet, my lord.
After, with FSL.
My lord, that without FSL, my lord, without FSL, my lord.
8. After extension.
After extension, my lord. After extension, my lord.
Why? It was already extended by another 6 months. They could have waited.
They can wait it, my lord, because this provision is there to up to 1 year, my lord. That
No,
is
no,
all.
they have, it was extended by 6 months.
Yes, my lord.
They could have, instead of filing charge sheet,
Yes, my
they
lord.
could have waited.
Yes,
to
ma'am.
get the
That
FSL.
can be also done, my lord. They, my lord, that part also, that note in the search sheet, what they have provided, my lord, that is also I have flag marked, my lord. In the
No,
CS.
that was my point, no, actually, the 22C, suppose. 22C,
My lord.
what? Psychotropic substance.
Yes, my lord.
Whether it is a psychotropic substance or not,
Yes, my
it will
lord.
be on the basis of what?
On the basis of the FSL report, my lord.
FSL
but-
report is not there.
FSL report is not there, my lord.
Then how can I say?
Yes, my lord.
So this is the question that bothers me.
Yes, my lord. Because, my lord, until, my lord, the FSL report is collected, my lord.
Logically, yes.
Yes, but no one can, my lord, determine what
Yes.
is the substance itself, my
That's why I
lord.
said.
That
what
is,
is
that is the
written
expert.
There,
Yes, my lord.
indicated,
Yes, my lord.
because it is not from
Now it is, my lord, is a
substance oriented,
substance
Law.
oriented, my lord.
different sections. for different
Otherwise, my lord, they made the prayer and that extension they get, my lord. The extension they get, my lord.
Lordship may consider. only
They
if
kept pending, my lord, that part, my lord. And, my lord, otherwise also, as because extension is there, today is only, my lord, 169 days from the, my lord, date of, my lord, that is his arrest, my lord.
180 days.
Not, even if this charge sheet is taken to be incomplete,
My lord.
then also statutory period is
11
not
days
over.
left, Lordship.
Not over, my lord.
Am I right?
That is my submission, my
Am I
lord.
right?
That is also not over, my lord.
This one.
Because, my lord, 180 days from the date of 31/7/2025 and from 31/7/2025 till today, my lord, 77 days, my lord, completed. So, my lord, 180 days yet to be completed. So my lord, 113 days yet left.
Your
my lord.
contentions are, what are your main contentions? That it is, one is that it is, you are not seeking default bail, right?
No, Lordship,
On merit,
on merit, Lordship.
but merit, you'll have to see 37.
Lordship, 37.
37, if it is recovered from them,
Lordship.
if it is recovered from them.
Yes.
Prima facie, though, it is.
Prima facie, my lord,
it's
case is there, my lord, because my lord,
Then,
Caesar witness
Plus
implicated.
will shift during the trial, if it's, the trial is there,
My lord,
to show that it was not conscious possession.
My lord.
Trigger 35 will be triggered.
my lord.
And 35, but to say that they are not guilty. In a 37 petition, the council will have to, as a council, I'll have to try to show the court as to, these are the materials which indicate that I am not guilty. That if I can convince that, then I will succeed.
My,
If the if the bail depends on 37.
My-
Now we are doing various other cases like procedure is there, those are
My
different, technical.
my lord.
The statutory bail is there. But if hardcore 37 has to be seen, then that determination
Right.
has to be done.
My,
I have to convince the court that this is not there. Convince not court actually, convince is the law.
my lord.
I have to pass that test.
From my lord, that
So on
extent
that
on,
aspect, what do you say? It was seized from them.
yes, my lord, because
As
my
far
lord,
as Caesar list
yes,
and
my lord,
everything.
Caesar witnesses are there, my lord. They also, my lord, said the same, my lord, because they are in the, my lord, motorcycle, and from there, them, my lord, that was, my lord, contraband was seized, my lord.
And that is-
And even, my lord, their story is that one of the petitioner who was, my lord, in the, my lord, petition, their story is that, my lord, that one, my lord, he take a lift of the motorcycle, but admittedly they said that there is something, because, my lord, in the para 7, my lord, of the petition, they stated, my lord, that the petitioner begs to state that they have fairly confessed before the police in the spot of investigation that the bag was given by Nizamuddin of Jaipur and the same belonged to him, but the police has detained, meaning thereby somebody has given the bag and they are carrying, my lord. Now, my lord, these are the case, matter of trial, my lord. Whether, my lord, these things will come out, my lord.
And Lordship, paragraph 6, Lordship, I have stated that the drugs were recovered from the bag about which the petitioner had no knowledge. Knowledge part is absent.
There's no case there is not there. Case
My lord, the entire case diary is not there, my lord. Or my lord, statements are there, my lord. The statement part is there, my lord.
there.
There
The
are-
investigation materials will be necessary to
My
determine
lord, my
37.
lord.
If it's sufficient, I will not delay.
My lord, otherwise, my lord, the statements are there, my lord. Statement I have flag mark, my lord. In the, my lord, CD, my lord. CD part, the statements are there, my lord. There, the Caesar witness is also there, my lord. They clearly implicated, my lord. Because it is in the Nakasiking, my lord.
It will be difficult then, Mr. Chaudhary. It will not be possible for the court. How can I say that they are not guilty? On what basis?
Their knowledge. is
Suppose
not there.
nothing is seized from them, then one can say.
My lord.
Admittedly, Lordship, because he is from their bike, Lordship.
Maybe that story is, suppose it's true also. Very unfortunate.
Lordship,
You
they have
know,
stated.
never accept
police
bags from
also.
anyone, non people.
My lord.
It seems.
Lordship, in the affair also, it is there, Lordship. During spot, the accused person stated that they have brought the bag containing from one Nizamuddin.
So, my lord.
So knowledge is, Lordship.
My lord, the bag is very much there with them, my lord. Now, from where the contraband my lord,
Suppose there is
See-
investigation materials of the kind that
My-
Nizamuddin was arrested.
my lord,
And he confessed that, yes, I had given the bag
my lord,
for them to take, In
My
that
lord.
case, maybe you can say
my
that,
lord,
yes.
my lord,
Maybe they may be victim of
my lord.
circumstances.
Only knowledge part, Lordship.
But otherwise it will be difficult.
Because, my lord, extension is also there, my lord, as per order dated 31, my lord, 7/2025. The 180 days extension by agency gate, my lord. And
Or we'll call for the case diary copy, then, full case diary.
Lordship may call for.
that can also be made, my lord. The entire, my lord,
Suppose
My-
it is rejected, then he will also have satisfaction that the
my lord,
full case diary is before the court and we
My-
have discussed it.
my lord, my lord.
Because
My,
once 37,
yes,
under
my lord, only
37
here,
the
my lord, only the statement.
petition is rejected, the court person doesn't have any option. Supreme Court or again the trial period, he may be in jail. So that will be just. I told you, no, in the Watali case, which is pertaining to UAPA, they have, the Supreme Court has discussed this thing, that the test of 37 is tougher than the test in UAPA. UAPA says that prima facie, not true. Here says not guilty.
Not true. 43D.
And suppose the court frames charge, suppose in a case, then after framing of charge, how can the bail court say that this is not? It's very difficult actually. It's practically, that means the law practically has said, don't give bail. Almost like that. Unless there's some exceptional circumstances that C has been, commercial section has been given, but nothing has been seized, then it may be, otherwise it is tough, very tough to pass this test. Anyway, so, Ayu Chaudhary Learned Counsel addresses arguments on the bail petition. Pertaining to Gwalpara PSP's number 83 of 2025, in which the two accused petitioners are in under trial detention since 1/5/2025, pursuant to their arrest. Full stop. The allegation is about recovery of commercial quantity within bracket 7661 numbers of suspected Yaba tablets from their possession. The petitioner contention is that they are a victim of circumstances as they had carried a bag in good faith given by one known person, Nazimuddin, Nizamuddin, who has not yet been arrested. The scanned copy of charge sheet and some documents have been received. Though some statements of the witnesses are available, but considering the fact that a full determination regarding the applicability of section 30, regarding the applicability of the rigors of section 37 of the act, has to be made, it would be prudent to peruse the full case diary. Therefore, scan copy.
Scan TC, scan copy of the CD.
Call for the scan copy of the case diary.
Along with the status report also, if in the meanwhile, my lord, FSL report is available.
A status report regarding the case.
My lord,
From
regarding.
the IO. No, from the court.
From the court also, or
Court
we
IO.
can take an instruction from the IO whether FSL is, my lord,
The
collected or not.
prosecution shall also take an instruction regarding submission of FSL report in this case. Release the matter on after you tell me that it.
My lord, any,
You discuss and tell me.
any.
Last is,
No, I don't know how many matters are said, no? I have no idea.
First
How
week
many
of
will be
November,
fixed? How many are fixed?
First week of November.
First week of November, Lord. Or last
7-11.
7-11, my lord, 7-11. My lord, same time, my lord, status of the case may be called from the, my lord, that is,
As from the court,
status report, yes, my lord.
a brief
Only the
status of the case shall also be called for from the learned court below.
Take your last. All right, and 40.
14.
Lordship, 40.
Just a minute, admission is क्या हो? Orders क्यों? बाकी खुद असल. I'm just trying to plan it out. Should we take, this is a appeal bail.
Lordship.
Should I take the appeal bail first, or if there are any short matters we can finish?
Yes.
The councils are there, short orders.
Yes.
No? Some steps or something.
Lordship.
Lot, बाकी का था, try version. 40 আৰু 44 টো থাকক এতিয়া। এটা চাওঁ কি আছে বাকি 41
As in the last occasion, I was advised.
That's why I'm taking on this small short point. So if you notice, sit back unserved. Impressive. PCR has been received. Kindly, why, what is the problem? What difficulty is being faced in servicing her?
I don't know, Your Lordship, on how many occasions we have taken.
Bhavna Garg.
Yes, in last occasion.
Lamding, she's not staying in Lamding.
No, Lamding, presently she is not in Lamding, I think. In the last
She's
occasion. I
informant,
was-
informant.
Yes,
She's informant.
in the last occasion, I was advised, Your Lordship, to communicate the informant through in her telephone. That means that his.
You have her phone number?
Yes, I have given the message, Your Lordship, but no reply I have received.
Yes.
These are the messages, Your Lordship.
No reply.
No reply.
No, she's actually, this better not to communicate with her. You know the person, she's known to you.
No,
No, better not for the petitioner to directly communicate, because after the criminal case. So what do you suggest? Newspaper publication, proceed.
My lord, that can also be done, my lord.
What else do you
Or-
do?
Or my lord, as because my lord, search sheet is already failed, to trial arm হৈছে নেকি? আমাৰ issue হয়, trial arm হৈছে। So whether my lord, to that, my lord, that is the court, my lord, this I think JMFC, no?
Yeah.
JMFC. So to the trial court, my lord, whether my lord, a direction may be made, so that my lord, according to that, my lord, it can be served.
Through court,
So-
how, JMFC in, हो जाए,
Yes, my lord.
JMFC in हो जाए.
Because my lord, trial is going on, but
Trial is going on.
trial is at Kamrup, Your Lordship.
Kamrup.
Kamrup Metro.
Oh.
GRPS case is what?
or to ইয়াত নেকি? Okay. So then, my lord,
Or otherwise,
I think if Your Lordship will give some observation in the order, Your Lordship, I will again communicate it to her mobile
no,
number.
don't give, better not to.
or my lord, from the
contact
jurisdictional
her
police
for this.
station, my lord, we will try it. Serve, my lord.
Rekha? Though scan TCR has been received, but the matter is
Lordship, I think it will better, Your Lordship, paper cutting will be the better. Your Lordship.
we're awaiting service upon the respond number 2/informant. It is submitted that though notice has been sent to the address appearing in the cause title, but it has not been successful. Also. So let us do that, notice through police station
My lord,
as well as newspaper
my,
publication.
my.
Then we
The
can.
problem is that, Your Lordship, her husband was railway employee, Your Lordship. At that time, she was posted at Lamding, but presently where he is,
I don't know, Your Lordship.
Then my lord, please get a report.
Therefore only I am
If
saying. Your
police
Lordship,
find
paper
my-
Publication, I think.
Through police station,
Through police
and newspaper publication also.
Yes,
Though, both.
yes, yes.
Then we can proceed. Do it properly, sincerely, then to complete the procedure sincerely, then we can proceed. The petitioner shall take fresh steps upon respondent number 2. And the jurisdictional police station
Jurisdictional police.
shall
station.
endeavor to effect the service upon the informant. Further, the petitioner side shall also resort to a substituted service by way of newspaper publication in a local daily. 2 local dailies?
Yes.
2 local dailies. This is the matter. This will require a month.
Yes, my lord.
Newspaper, filmmaker. Fix it after 40 days.
Yes, ma'am. Well, here, my lord, the jurisdictional police station will be Lamding, my lord.
Lamding. Jurisdictional police station.
Lamding police station.
Within bracket, Lamding PS.
Lamding PS, ma'am.
Interim order is there, Your
No,
Lordship.
it will be- The interim order passed by the order dated. This soil. Shall continue till the next date of listing. This is the matter on approximately 40 days would be good.
Yes, ma'am. PS.
Complete everything, then we'll proceed. If she does not. Till today is 15 November. 25/11. 25/11. This you can take if you want. What is
May I please, Your
It has come up.
Services awaited, Your Lordship, but soft copy to the. I beg to inform you, Your Lordship, on last occasion, during the motion day, I had prayed for an interim order. So this honorable was pleased to note that it will be considered on the next day. So my prayer, Your Lordship.
Just a minute. It was taken by registered AD on 3rd January,
My lord,
but nothing has come back.
my lord,
Office
Should
note.
we assume criminal case,
my lord.
27 General Clauses Act. Scan copy is received. Charge frame, no?
Charge is frame, Your Lordship, but.
Trial is going on.
No. May I give submission a little bit?
Yeah.
What
All right.
happened, this is a government sponsored scheme where timbers are given to the beneficiaries in 2019-20, Your Lordship. And we as the accused are the truck owners. So the owner and possessor, everything is in the hands of the government. So the authorities would supply according to the scheme. So what happened in 2020-21, there was a lockdown because of the extreme coronavirus pandemic. So the work was stalled. So there was a delay, which is beyond our control. And thereafter, after the lockdown, in the council areas, there was this one. His Excellency, the Honorable Governor's rule came just before the previous council election, not this year, but previous council election. So after that, all the difficulties were over.
And after that, when we started to resume to proper challan issued by the government only, by the authorities only, when we wanted to deliver the timber, suddenly this unknown person who is not the beneficiary, informant, he filed an FIR. And considerably our trucks were seized and accordingly the logs were seized. Here in this case, it's a documentary evidence matter, your lordship. And here in this case, the original documents were never seized. So at the time of framing of the charge, we filed petitions before, at the consideration of charge, we filed petition before the learned trial court and to discharge us fully because there was nothing fault in us. In the Ezahar, it is written that
The prayer for discharge was rejected.
no, in the when the when the prayer was heard, the learned trial was pleased to drop section 420 slash 34, section 406/34.
But charges were framed in the other.
Section 409 was kept. I'll come into it. Slash 34. Strangely, 34 is taken as the standard charge. In 420/34, 406/34, and 409/34 is maintained. So for trial it was ready, so framed for one section of that one, and accordingly notice were issued to the PP to summon the PWs. But during the time of consideration of the charge, the learned trial court had asked for the original materials on records actually from the investigating officers because entire thing was based on duplicate copies, which cannot be entertained. So they took time for this, and till now the trial could not be commenced. It's a matter of 3 years now, so trial is awaiting. So, Your Lordship, what happened in this case? In this case, when we submitted the information to the learned trial court concerning this matter. This is a timber matter, which is very durable matter. The beneficiaries have suffered like any just because of this what do you call it, the case. They have not availed the, I think it is soiled already. So great injustices occurred to the beneficiaries who are very poor, and surprisingly they have not come before this honorable court with a writ petition. They could have approached this honorable court with a writ petition. I don't know why they have not approached, but the IO, the investigator filed a petition to deliver the timbers to the DFOs, to the officers, but I don't know what is the condition now. Just because of had interim order been given, Your Lordship, had interim order been given, this situation would not have. Just because of this, somebody who is not even the beneficiary, out of personal vendetta, he has filed a FIR against. We are just truck owners who has to deliver the timber free to the beneficiaries. This was the case. We could not deliver on time because of the coronavirus and Honorable Governor's rule. So when we started to deliver for the 2019, this Ezahar was lodged and our timber was seized. What is mentioned in the Ezahar is, if this one house is completed, how could you, from where are you transferring or delivering the timber? For what purpose? Houses are already complete. But then there were two schemes. Prior 2017 scheme was there. That house is complete. We have delivered the timber already. But this house is not yet complete. The work is not yet even commenced, Your Lordship. So we were trying to deliver so that the work could be commenced. The houses were built for the poor beneficiaries in 2022 because of the delay. But this through false allegations and through total abuse of process of law, this Ezahar was filed, and so we filed a discharge petition.
Anyway, so but the respondent service, his phone number is also there in the FIR.
Everything is there. He's not responding.
Then throw the police station. Throw police station, my lord. It is from Sidley, my lord.
Or otherwise, I can take fresh steps. He's there. We know him.
You can throw the jurisdiction police station.
Same of it. Those scanned PCR has been received, but
That's why we prayed for the stay, Your Lordship.
and additional PP Burso, K Burso.
Once trial commences, I'm afraid what would be the condition of the logs and the timbers?
So those can TCR has been received. But case is
23 witnesses.
awaiting service upon respond number 2/informant. I find that his phone number is also available in the full stop, though steps by registered AD was taken, but service report not yet received as per office note. The petitioner shall take fresh steps upon the respondent number 2, whose phone number is also available in the FIR. And the said service of notice will be effected through the jurisdictional police station.
But that is my lord, Runikata Police Station, my lord.
Rumikhata.
Runikata, my lord. Here it is.
Rumikhata Police Station in the
Rumikhata.
district of Chirang.
Sirang, my lord.
ETAD. Full stop. Further, it is directed that further further proceedings in PRC case number 105 of 23 pending before the court of learned additional CGM Chirang Kajolgaon shall remain state till the next date of listing.
Highly obliged. Your
Next date to the next date you decide. You tell me.
After Diwali.
First or second? No, it can be in first week of November.
Yeah, let it be in the second week of November, your lordship. First week I will be absent.
10, 11?
Highly obliged, your lordship.
10, 11.
10.
Short হলে রোমান নহলে তো লাভ নহব।
May I please, your lordship?
Mhm.
Lordship, on the last date, this court had directed the registry to update the office note of the tracking report served on the respondent number 2.
Again, this question comes here. We can take, can it be taken to be, deemed to be solved?
Lord,
AD card, it was sent by registered AD through
Lordship,
the.
as per my personal inquiry, it was served on the respondent number 2.
Acha.
In fact, the registry, I had also give them the copy of the tracking report by personally taking out from the post office printout.
They have not mentioned about the tracking. They have not mentioned about the tracking. Deemed to be solved, we can take it.
Tracking report, my lord, but
Tracking report is not.
that is not
should be
reflected, my lord,
reflected actually.
in the office note, my lord.
As per office note dated 13/10, notice served through registered AD has not, sorry, service report with regard to notice sent by registered AD has not been received. The office note does not indicate about the postal tracking stated to have been submitted. Comma. The registry may kindly look into that aspect and indicate regarding the postal tracking report.
Lordship, there was
Interim order granted by the order dated 16/12/24 shall continue till the next date of listing. Fix on it be in the 4/11.
Lordship,
4/11.
highly obliged.
5 minutes. So actually this.
Lordship, may kindly peruse the last order.
It's not part order, it's a different matter. Last order, okay.
Yes, Lord.
You've lost contact with the petitioner, you have lost contact with the petitioner.
Yes, sir. Yeah, but that is a problem.
In fact, Lordship, there is no scope of any compromise or resettlement because at the page 18 and 24 of the judgment, Lordship will find that
It is against, revision is against maintenance order.
no, against decree of divorce. Decree of divorce along with
To survey,
I've read, that's why I said, it was the last order.
leave it to
I
my
said. Well, postal tracking, can you find out? on the-
that the poster generally made by the registry, my lord. So that's why the
No, no,
track report
Ah.
comes there, my lord.
comes there.
Yes, ma'am.
So can we direct the registry to see, check,
My
put
lord,
up a note
my lord,
regarding postal
my-
tracking?
my lord.
The registry may look into the aspect of service and check whether any postal tracking from the dispatch it goes, no? Postal tracking is available. And if so, note may be put up accordingly. This is the matter after 4 weeks on 11, sorry, 13/11.
My lord.
Stop. You need that husband?
No, my lord.
I can
If you
keep-
kept on record.
Oh.
Deeply obliged.
Acha, there are two cases, no?
Two cases, same, my lord,
Same order,
same order would be.
two checks.
Two checks, my lord. That filed two
Same.
cases. I'm obliged, my lord.
The line he talks, petitioner. One line I am just adding for future reference, even if it comes before another bench. The petitioner has filed this criminal revision aggrieved by refusal of the learned trial court to pay interim compensation in terms of section 143A of the NI Act, right?
My lord.
Obliged.
May I please, your Lordship? Lordship, my senior is not available today. Finally, matter may be taken up after 2 weeks.
Yes. Interim compensation again. You are the complainant? You are for
I am
the
complainant.
complainant. They have to start the argument. So, no, because he's seeking an adjournment. Do you want to say something?
The Lordship, this case is actually, it will be, once you hear my case, you will dismiss it at a revision stage itself. It's, this case was filed in Hosai CGM court. And the case was running on, going on, and after, when the accused was not appearing in the court, when the court lastly issued bailable warrant, he appeared before the court. And before that, when the legal notice was served about the payment of the check amount, he did not bother to even reply to the legal notice. Now, after this, when he did not, when the court ordered when after issuance of bail order, he came and surrendered before the court granted bail. Meanwhile, this under section 143A of the Act, NI Act.
I'll give your senior an opportunity. No problem, don't worry, but just trying to understand.
I applied for interim compensation. As the things were getting late, so my money was involved. So to take care of my money problems, I prayed for an interim compensation of maximum permissible to 2 lakhs. But the court did not grant me 2 lakhs, and it granted me only 1 lakh. I was happy with that. But once this order was passed, they have come to this court for relief. Now, the point in the way of filing this petition, now through this section 438 read with section 442 of BNS 23, it is found that the scope is limited to the jurisdictional errors or patent illegality. The present petition under the garb of revision petition seeks to reappreciate the evidence which is impossible in the court, in law. They want to reopen the entire thing. Here only the their petition is why it was, they have not issued. And they are saying so many things that I had gone to their village at 11 of midnight with goons, and even police were with me, and I collected a check signed by him. But the thing is that after, so if I had done that, they could have easily lodged the FIR. They were waiting for me to file a case. After the case, and after filing the case, after 10 or 12 months, they came with this story that I barged in their.
Anyway, okay, where is the impugn order? This is the impugn order. 19/6, most probably, no?
This was
Okay, I'll read it. I found it.
page number 30, there, order is there. Page number 30.
So let us see what they say. Okay. Your Miss Asad?
Yes.
Your good name, sir?
G.K. Gupta.
G.K. Gupta, learned counsel, appears for the respondent complaint and addresses his argument. Should I keep it as part heard? Should I keep it as part?
Yes, that will be better. Your lordship.
Address his arguments. Full stop. Learned Ms. Pasak, learned learned counsel for the petition. One of the learned counsels for the petitioner submits that the leading counsel has a difficulty to the seeks an adjournment. Where is allowed, the matter may be kept as part heard. List.
Lordship, interim order.
Interim order granted by order dated 18/8/25 shall continue till next date of listing. List, you kindly suggest a date. You suggest a date. Revision.
November 10th.
Okay.
10th November.
November 10th. Done. Hello, no, sir?
Obliged.
What is that? No, no.
Wait, please, Lordship. Lordship, as per order dated.
দুটো আছে না? 40 করুন।
As per order dated, my lord, 28/7/2025, I have deposited, my lord, 25% before the registry. But due to some financial problem, I could not arrange the entire amount. So, my lord, kindly some time may be given, my lord. I will deposit the amount.
25% of,
Awarded amount is an act case, my lord.
as.
Yes, yes.
Just.
Kindly see the order dated 27/2025.
Oh, that,
Passed by this honor.
there's no 20% deposit.
Yes, ma'am.
Deposit of at least 25%
At least
deposit.
25%. I will pay, my lord, due to some financial problem. Entire amount I could not.
Actually, no, see, the thing is, I have encountered this problem in district also. If you see the provision, it has 60 days and another, 30 days, I think. Thereafter, it cannot be, there's
Yes.
no provision for
Yes, yes.
extending it beyond that. Anyway, but this court also has 482, so maybe otherwise.
If possible, my lord.
while order dated 28/7/25,
Yes, yes.
the execution of sentence was suspended subject to deposit of 25% of the fine amount within on or before 1/9/25.
Yes.
You have deposited some,
No, my lord,
nothing.
nothing, my lord, because my lord, entire amount I could not be.
25%, the 25% of the amount comes to rupees, how much?
Almost my lord, 1,80,000 something.
The check was of, the award was.
7,50,000.
Oh, then it will be in fraction. It will be in fraction. I do not like it. 20% of the check amount, like, 20% of the fine amount, 20% of the fine amount of 7.5 lakhs comes to rupees. It will be calculate quick. Full stop. It is submitted by learned counsel that due to his financial difficulties, he has not been able to pay the amount and seek some time. See, I will show you this. What is the provision? 141, no? 42.
148.
No, interim compensation. This is not interim compensation.
148.
It's a judgment. No, the 142 is interim compensation. Interim compensation. One 148. See, within 60 days and
143.
further period not exceeding 30 days.
Yes.
Within 60 days. So the court said rightly that 28/7, so 28/8, 28/9. Achha. 1/9. 28/10. Actually, as per the law, you have maximum time till only 28/10.
I'm leaving it to you, doctor. I'm leaving it to you.
No, no. And this problem I said, I faced. People seek extension, but law actually does not permit. Law does not permit actually. It will be an irregular order even if it is passed by High Court. The petitioner is directed to clear the amount by 15/11.
15
15/11/25. No,
Obliged.
there's no scope actually.
Yes,
That's why I am not referring also.
Highly obliged.
This is also not fully correct actually.
Yes.
List on 15/11.
Deeply obliged.
Interim order passed earlier shall continue till the next date of listing.
Obliged.
Quickly come, let's finish it.
My lord, as per order dated, office note dated 13/10, notice though served, it has not returned back. Upon respondent.
We'll wait for some time. Shall
Yes,
we,
we can wait, my lord. No, may I pray for listing it on?
Wait, just a minute. Service report with regard to respondent number 2, not yet received. Receive back. Await, list the matter on
13/11, my lord.
13/11.
13/11.
Okay, 13/11/2000.
Then, my lord, probably you can take the presumption also, my lord.
Let's see. 13/11.
Obliged.
Okay.
Further, my lord,
Fine. Okay, 15 earlier council, who's that? Oh, 15/11 is a holiday, seems. 14.
Obliged.
56. My lord, in that, in my matter, my lord, 46.
56.
46 to my lord.
The 46 I have passed order.
My lord, one prayer, my lord, small prayer there. My lord, is it possible, my lord, the registry may be directed to give the track report also?
the registry may also put up a note regarding postal tracking.
Yes, my lord. Obliged.
A supply of orders got. None appears. At least the matter on. Did you take 52? Very good. 611. Come. 44, no? But it's over. No?
10 years, my lord. Please.
The hearing,
Yeah.
all the hearings, just.
And today is my lord. List of date to this.
Hearing or dissenting? মানে হেৰি appeal hearing নে হেৰি hearing? I hearing নে appeal hearing?
Just list of dates, madam, for the, just to save time.
Today we are.
Half of the sentence, he was convicted for a period of 10 years and almost 5 years is completed. Will be completed by February 2026. So, Lordship, any other date may fix in the first week of November.
Could not be IA to mean to.
It may come up, Lordship, come up for in the orders column. Lordship.
The matter could not be taken up due to paucity of time. List, you can suggest list in the orders column on.
My lord. Any date, my lord.
After how long? 11/11, you can fix.
11.
I feel, personally, I see a lot of scope for use of AI in date management and
Yes,
case
ma'am.
management.
Yes, ma'am.
You can work miracles, believe me.
Yes, my lord. So now, my lord, is the time, my lord. We
Yeah,
have
it
to
can work
move for all
miracles.
these things.
Mm.
My lord.
The waiting will also reduce.
Yes.
I know how tiring the waiting is
Yes,
practiced.
yes.
Yeah. You know, don't know.